my lord, I, my lord, filed one writ petition, my lord, for payment of bills, my lord, contact bill, my lord. In the meantime, my lord, the respondent authority has, my lord, cancelled this, my lord, contact order, my lord, to give this work order to somebody else, my lord. So I have filed one writ petition, my lord. Kindly this matter may be taken up tomorrow.
Cancellation
Yes, my lord.
of the work order
Yes, my lord.
tomorrow.
Diploma.
I beg to mention for listing two petition lordship.
Subject, listing, old or new,
New lordship for motion.
subject,
Subject for settlement of market lordship.
filing.
For tomorrow lordship. Tomorrow.
What is the urgency?
Yes, lordship. Already filed.
What is the urgency?
Lordship. It may already filed in 31st of July, lordship.
Then must be defective.
No defective lordship. Actually, matter was adjourned on 5th of August.
Matter is adjourned. That is, tell that. Adjourned for what period?
For personal difficulty of my senior lordship.
Huh?
For personal difficulty of my senior lordship.
Friday then. There is no urgency then, that means. Friday.
May please lordship. I'm praying for listing of a petition lordship. Lordship, regarding lordship, the withdrawal of PSO from this petitioner lordship. Urgency is there lordship possible on lordship 24th.
Class 5. Other civil rules.
Lordship, I mentioned.
Two admitted amount matters by the railways, writ petition. Old matters by the railways, admitted amount. 2017 and 2020,
Repetition. Okay, next week.
Monday.
Next week.
Madam.
Next week.
Wednesday, Monday.
May it please, your lordship. Lordship, I beg to mention an item for listing, your lordship. It's a writ petition, your lordship,
Wednesday.
pertaining to non-payment of contractual dues, your lordship.
Repetition new or old?
New, your lordship.
Next week.
Monday, your lordship.
Wednesday.
Wednesday.
Daily list, top of the list, item number 1.
May it please your lordship. Lordship, this is a matter regarding payment of gratuity. We had challenged the order of the learned Assistant Labor Commissioner.
Let us see the order.
Order is starts at page 17.
The payment of gratuity act concern. Yes.
My lord, our contention as the petitioner industry, our contention is that it was a purely contractual appointment.
No, firstly, come to page 18.
Yes, your lord.
There were 4 issues
Yes, your lord.
before the controlling authority. So what is your submission as regards issue number 1?
My lord, because the employment was with regard to contractual appointment, it was not against a sanctioned post. It was not a permanent employment.
We
As
come to
such-
that first issue,
As-
whether that agricultural and processed food products export division authority, development authority,
Yes,
is an establishment or not?
it's an establishment.
There is no dispute about it.
No.
Now, whether the applicant is an employee under the provisions of the payment of gratuity act. Second issue. So you are harping on the second issue.
Second issue.
Okay,
My lord, our stand is that the employee from the very first had been a contractual appointee in the post of peon, not in the post, but as a peon, he was appointed as a contractual appointee, not against the sanctioned permanent post. As such, the actual benefits which arises from a permanent post may not be, he may not be accorded the benefits which arises from such a post.
so your submission is based on what? Let us see the definition of employee.
Two E
Hmm.
employee means any person other than an apprentice who is employed for wages, whether the terms of such employment are expressed or implied in any kind of work, manual or otherwise, in or in connection with the work of a factory, mine, oil field, plantation, port, railway company, shop or other establishment to which this act applies, but does not include any such person who holds a post under the central government or state government and is governed by any other act or by any rules providing for payment of gratuity.
Now, employee means any person other than an apprentice who is employed for wages. Now, why contractual employees will not come into the picture? Within the ambit of this definition. There is no exception that contractual employees are to be out of the ambit and purview of employee. It is employed for wages.
Yes, yes, sir.
So where is the appointment?
Lordship,
Engagement?
Section 1, subsection 3, if it is taken into consideration,
Which one?
section 1 of the
Ah.
payment of gratuity.
Hmm.
Subsection 3, your lordship, it shall apply to every factory, mine, oil field, plantation, port and railway company. Every shop or establishment within the meaning of any law for the time being in force in relation to shops and establishments in a state in which 10 or more persons are employed or were employed on any day of the preceding 12 months. Your lordship, I would take a break and lordship may be pleased to see para 1 of my writ petition, my lord. What you may read.
Do you have the
technical-
act? Do you have the copy of the act? There is the act. Do you have the copy of the act?
Lordship, actually, there is an analogous matter, item 16 today in today's list with the same petitioner and the same respondent. In that writ petition, it has been annexed the
16. Right. Yes. Yes. It is annexed here.
yes. My lord, in the item number 16, the from page number 49, my lord.
49.
The act is there. my lord. If my lord wants to produce the functions of APEDA, it's in page 55, my lord.
Is 55.
Yes, my lord. Point number 10. Those are the functions of the authority.
So it is a statutory body
Yes,
because
this
section,
came into existence by an act.
yes. Section 3. Section 4(1). So it is a statutory body.
Yes, my lord. My point is that, my lord, in the present petition, it has been, there is a stand of the petitioner. The
Just
authority
see,
in para 1, my lord, towards the end. The aim and object of the authority is to help in the development and promotion under the control of central government of export and scheduled products as envisaged in section 10 of the Act. The authority has a small office at GS Road, Guwahati, comprising of 2 officers only, and the petitioner number 2 is the Assistant General Manager of the Guwahati office.
what's it? Huh?
My lord,
Two,
the
two employees. You want
two
to say?
employees, my lord.
Now, have you taken that contention before the controlling authority?
My lord,
Have you made that assertion before the controlling authority?
yes, my lord.
Let us see. CGC, available CGC. Yes, Regional Labor Commissioner. Okay, where? It is reflected.
The name is shown CK Sharma Barua appearing in this matter, Lord Chair. I just informed him, Lord Chair.
Take the second file, go through it.
Lord Chair, I just informed Lord Chair.
Where it is mentioned. Because it was contested, right?
Yes, my lord.
One general manager appeared.
He took the stand that it was a contractual appointment.
Okay, but
Only that
definition
ground
of
has been-
employee does not say so.
Only that ground has been taken.
Definition of employee in the act does not make any exception for contractual employees. The requirement is wages.
Wages.
Now, you are pointing out to section 1 or one 3B.
Yes,
Now, what is there in the judgment or order, whatever? Impugn order.
that ground was perhaps not taken either.
Now, tell me the scope of an ambit of 226 against an order. Okay, this order is passed in exercise of what power? In the act controlling authority, payment of gratuity.
Section 3, my lord.
Section
Payment of
3 is the
gratuity.
controlling authority,
Yes, my lord.
payment of gratuity. Then I think 7, he makes mention about something 7,
Determination of the amount of gratuity.
4. Which is eligible for under this right is authorized. 7, 4. A controlling authority. 7, 4C. Okay, against the order of the controlling authority. Right?
Yes, my lord.
Is there any provision for appeal? Or writ petition is the only way out?
If my lord peruses the affidavit in opposition filed by the respondent number 1 and 3.
No, come to the act first. Come to the act.
Yes, my lord.
7. A High Court rules concern. First, you see the 7-6. It appears to be a judicial proceeding,
Judicial proceeding.
right?
Yes, madam.
I'm sorry, your lordship. If it's just not.
So there was a provision for appeal under subsection 7.
My lord, in the rules, it's there.
No, in Act itself,
Payment
Act
of,
subsection 7 of section 7.
yes.
Now, there is a provision for appeal.
Yes.
Then second proviso to subsection 7 says that if the employer is the appellant, then he requires to deposit the amount determined under subsection 4. So there is a provision for appeal,
My lord.
which you have bypassed, right?
Yes.
By filing this writ petition. And the appellate authority is a final arbiter of determination of facts.
Yes, my lord.
In writ petition, unless you show that this controlling authority has exceeded his jurisdiction,
Yes, jurisdictional point.
in some manner in determining the dispute regarding gratuity, then you can maintain a writ petition. But so far as factual things are concerned,
Yes, sir.
right? That determination, I think, scope to examine that is very limited in 236,
Yes, my lord.
unless it is perverse. Right? Now, so far as a point which is not raised before the controlling authority,
Yes,
and in the absence of any appeal, whether that point can be taken in a writ petition, because we are into certiorari jurisdiction.
226.
But subsection 6 says it is a judicial proceeding.
Yes, my
The
lord.
proper proceeding ought to have been under 227. But you are into 226, making it more limited. This is under 226.
Yes, my lord.
So otherwise it would have been registered as CRP if it is 227. Now, scope is limited. Now, how do you say that that point which was not taken before a controlling authority regarding the two employees? Can it be taken in a writ petition? Am I clear?
Yes, my lord.
Merely making a statement will not do.
Yes, my lord.
You have to show me that this kind of statement can be taken for consideration in a writ petition. When the appellant, employer, without filing the appeal, has come straight away under Article 226. Because we know 226 is about certiorari,
Yes, my lord.
that jurisdiction is limited. Natural justice, that appears to be not violated, both parties
Okay.
participated, right? They were given opportunities to advance their sites, their cases. Thereafter, determination is made, factual determination is made. Even if some factual disputes are there, it is the appellate authority who can finally decide it. But writ court is not going to examine factual things.
Yes, my lord.
Is it so? So within that limited jurisdiction, what is your exact argument?
Our main contention, my lord.
These two, you have to support with something because we cannot take it at the face value because that was not raised.
Yes, my lord.
Is it so? Is it raised? No, it appears to be no. Now you have come up in paragraph 1. Is it not?
Yes, my lord.
Now let us see.
My lord, our main contention is that the jurisdiction point, my lord, the Payment of Gratuity Act does not apply.
Definition says so.
That being
Let
a
us see the appointment order,
appointment is a page
engagement.
11, my lord. Appointment order, it's just a contract, my lord. The terms are there, very specific, my lord.
Whatever, 8,400 per month wages.
Yes,
Now show me by any authority that contractual employees doesn't come within the purview of gratuity.
but for the incremental benefits to be accrued, my lord, there has to be a permanent employee. And
Show
for
me that contractual employee is not required to be covered.
perhaps my friend is relying on the judgment of Supreme Court when when there is no such sanction post or irregular
That
appointment
is regarding service jurisprudence.
clause.
There are different kinds of employees, right? We are dealing with a beneficial legislation in the form of payment of gratuity act, right? The normal government service is different thing and this is an establishment. Here it is not government, it is an establishment, right? Whether it is an establishment and whether it covers, you don't have any scheme.
No, my lord. The post now, as of now, it has been abolished in 2011.
Whatever, but we are concerning with that.
My lord, if it has been abolished, can the court under Article 226 direct for again reinstatement
That
Or-
we are into gratuity.
or for,
We are into gratuity,
yes, my lord.
Mr. Borua.
Actually, what has happened, my lord? The item number 16, that's a analogous matter. Same petitioner, same respondent. He has challenged his termination.
Okay, come to page their affidavit. Let us see. 1 and 3. Oh, that is different.
If my lord peruses para 16 of their one and affidavit of 1 and 3, para 16, the appeal provision has been,
It is there.
I mean, at that
Statement.
Yeah, but the petitioner deliberately acted
That's
against the interest of,
controlling authority and
by not applying for appeal.
temporary charge. No, what is page 16? Paragraph 16.
the appellate authority was lying vacant at that point of time, I guess.
Appellate authority is appropriate government. No, you have said so in your repetition that we do
No,
not want
no,
to go.
my lord,
Why we have not gone?
not stated anything.
We have not gone.
We have not stated anything, my lord.
Ah,
My lord, because we have got out a jurisdictional point.
What is the jurisdiction point?
My lord, payment of gratuity does not apply, the act. To our,
Show me some establishment that 1, 2, B, 1, 3, 1, 3. C is not available. Paragraph.
paragraph, my lord, para 6.
This is for what purpose?
My lord, he was who was working on daily wages. His services were terminated in 1993. For payment of gratuity, he filed a petition.
This is before Central Administrative Tribunal.
No, my lord, I am placing it for like contractual appointment. The benefits won't be accrued.
These are, this thing are for regularization. Is it not?
No, my lord, it was for distinct. For retirement benefits, he was asking a daily wage.
Uma Devi. You are relying on Uma Devi is a different concept. Entry is illegal. Continued in their post
Contractual,
for more than 10 years, 20 years. That was in the context of
my lord,
constitutional jurisprudence.
if I may read para 6, my lord.
Read.
Thus, it is clear that adherence of the rule of equality in public employment is a basic feature of our constitution. Since the rule of law is the core of our constitution, court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirements of Article 14, read with Article 16 of the Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. If it is a contractual appointment, the appointment comes to an end and at the end of the contract. If it were an engagement or appointment on daily wage or casual basis, same would come to an end when it is discontinued. Similarly, a temporary employee could not claim to be made permanent on the expiry of his term of appointment. It has to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, he would not be entitled to be absorbed in regular service or made permanent. Merely on the strength of such continuance, if the original appointment was not made by following a due process of selection as envisaged by the relevant rules. My lord, in my case, there were specific terms for which the contractual appointment had taken place. And after the term had expired, my lord, he cannot as of right claim to be absorbed into regular service.
No, here he is asking for gratuity. We are looking into the aspect of gratuity and the order, validity of the order of the controlling authority. Is it not?
Yes.
Now, this is a different aspect. Regularization is a different aspect. Whether here is your case, you have engaged him by way of contractual engagement, right? And he continued for a period for about 11 years with intermittent breaks,
Yes.
right? And when gratuity is admissible, otherwise, when
Section 4, my lord, payment of gratuity.
not less than 5 years. Right? Now, what is the, let us see the stand by the respondent. What is Form 9 and Form N?
The application of provision of payment of gratuity is from pair number 8, lordship, where the case of the petitioner has been covered.
Respondent one says in paragraph 11. It is an establishment under 13C.
Lordship. In fact, the same thing has been repeated in this para number 10 and para number 8, Lordship.
I've seen, no, he is raising about an issue, 13B. So para 11. It says that you have branches all over India,
My lord.
and so you must have employees of more than 10. Now, have you controverted that position?
No,
Paragraph 11,
additional affidavit has not been filed.
reply not filed. So you raised unsatisfactory performance.
Yes, my lord, there were allegedly incidences of some
But there was nothing,
Theft
you could
was
not
also-
prove it,
was not proved in the,
could not prove it
no, my lord.
before paragraph 13. Same could not be established in the course of hearing before respondent number 3, that is controlling authority.
Yes, sir. That stealing.
Yes. Yes, Mr. Borua,
Lord,
come to page 14. Petitioner. Right,
What a
come to
petition.
page 14 of the affidavit.
Yes, sir.
There is an engagement letter. Contract basis,
Yes. Yes, my lord.
28/9 to 1998.
Yes, sir.
Para 2. Period from 6/10/1998 to 5/1/1999.
Yes.
Next page. Para 2. 6/1/1999 to 5/4/1999,
Yes, my lord.
right? So no break. No break
No break, my lord.
from October to April. Then
6/4/99 to
5/7/1999.
7/19.
Then 6/7 to 5/9. Right? Then 6/9 to 5/12. 5/12, right?
Yes, my lord.
6/9 to 5/12. That is 99. So it is about more than 1 year. without any breaks. I don't think so, apart except an apprentice. Any difference is made, distinction is made between contractual or regular or ad hoc. Definition, employee.
Yes, my lord.
Can you find out some distinction?
No, my lord.
That Kumari will not applicable. Here we will go by the definition. Employee means any person who is employed for wages. Wages is fulfilled. Whether the terms of such employment are expressed or implied. In any kind of work, manual or otherwise, in or in connection with the work of other establishment to which this act applies. But does not include so and so, any such person who holds a post under central government or state government is governed by any other act. So this inclusion, exclusion part is not applicable because it is a statutory body, not central government. But so far as this 1(3), section 1(3), whether it is B or whether it is C.
C will apply once. Central government.
By notification specify in their behalf. Is there any notification?
No, my lord.
So simply making no will not do. Now wages have been defined.
2S.
What does the rule say?
What are the gratuity rules?
Hmm? Ordinarily.
The rules are in relation to conduct of proceeding. madam.
Come to rule 10. The claimant employee may within so and so apply in form 9 to the controlling authority for a direction under subsection 4 of section 7. Sufficient cause after expiry of the so and so. Come to 11(3). A party appearing by an authorized representative shall be bound by the acts of the representative. Whatever your authorized representative has submitted before the controlling authority, the establishment is bound by it. That 2 employees, that was not taken.
That ground was not taken.
Not taken before the, it is not your pleading also that we have raised the issue and that controlling authority ignored it. It is not your pleading.
Yes.
It is your pleading, we have 2 employees in Guwahati office, so we do not come under the party. But here, rule 3 of, sub-rule 3 of rule 11, it says you are bound by the acts of your representative. Now come to section 14. Provisions of this act or any rule made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act, or in any instrument or contract having effect by virtue of any enactment other than this act. So this act has overriding effect, meaning there are all these decisions will not apply. We will have to confine within this act.
Yes.
Am I clear? Am I right or not? That is what I am asking. I am reading it for the first time. Now 16(2), rule 16(2). The controlling authority shall 1. The controlling authority shall record the particulars of each case under section 7 inform Q and at the time of passing order shall sign and date the particulars to record it. Sub-rule 2. The controlling authority shall, while passing the orders in each case, also record the findings on the merits of the case. 17. If the finding is recorded on the sub-rule 4 of Rule 11, that the applicant is entitled to gratuity under the Act, the controlling authority shall issue notice to the employer. Appeal. 18, Rule 18. So in the backdrop of these provisions, you tell me the ambit, scope and ambit of your petition under Article 226. That is the only issue to be addressed. How, to what extent this court can probe inside the findings recorded by the controlling authority. And in the absence of preparing an appeal.
Yes,
That is the issue here.
the crux.
Am I clear?
Yes, madam.
That is, you address on that point.
My lord, my submission would be on the crux of the matter pointed out by your lordship. We had approached this court under Article 226. Harping on the jurisdictional issue, my lord.
Jurisdiction, what jurisdiction?
Issue that Payment of Gratuity Act does not apply to our organization
But
or the concerned petitioner.
is it the issue raised there? No. No, that issue is not raised there.
In the lower forum.
In the, before the controlling authority, it was not raised, right?
No, it was raised, my lord. That is the main issue.
Where is it?
My lord, page 18,
Page 18,
if I may read, my lord.
which paragraph?
The second para.
Yes.
The first para, my lord. A reasonable opportunity was given to both the parties to defend their case by way of oral written submission. Applicant submitted his letter of appointment dated so and so, issued by the opposite party to prove his claim of initial appointment and continuous intermittent engagement respectively under the employment. Applicant has also submitted that at the time of retrenchment by the opposite party, he was drawing monthly wages, so and so amount. The opposite party did not
Did not contradict.
the particulars of the date of the appointment,
And last. week.
intermittent employment, and last wages drawn by the applicant, etc. Since the said documents are the matter of proof on
On
record.
record.
Opposite,
Yes.
opposite party deliberately engaged the applicant on intermittent basis, a short break in service in between two contract periods, with a view to deprive the applicant from the various benefit accrued from the social legislations, like the PNG Act, though the work performed by the applicant was perennial in nature. Also, there was sufficient nature of work in the establishment of the opposite party to employ the applicant on regular basis. Applicant was employed with the opposite party for a considerable period of 13 years as per records available on merit. Opposite party submitted that the service of so-and-so applicant was terminated due to unsatisfactory performances in stealing the documents from the opposite party. Moreover, the opposite party has found that an examination of the application for eligibility of gratuity in light of the provisions of the law, rules and regulations, the contractual workers engaged on 6 monthly basis are not found eligible for payment of gratuity on termination of contract due to unsatisfactory services. No question of jurisdiction.
Unsatisfactory performance, termination.
That is
You
on
are
merits.
speaking about termination.
That is on merits.
That is about termination, unsatisfactory.
Whatever that is valid or not.
Then continue.
The opposite party did neither submit any documents regarding unsatisfactory performances of the applicant nor any proof of stealing of
So
office.
that is gone. That is an allegation,
My lord,
right? That not, that fact is not established. They submitted. So where the question of jurisdiction can be raised at any point of time. That is purely a legal issue. Now, how he has exceeded jurisdiction?
My lord, if the act is not applicable,
No,
if the
act is applicable,
my lord,
establishment, you are an establishment.
my submission, my lord.
1 to B, no, that has to be shown by the authority because he has come to next page. He has clearly made it clear, paragraph 1. Establishment belonging to under the control of the center having branches in more than one state and covered under the provisions of 13C. He has made a categorical finding that 13C. Now there must be a notification because it is statutory body. So there must be a notification that this covers under the payment of gratuity act. And he makes a categorical finding, 13C.
My lord.
Is it clear?
Yes, my lord.
Lordship,
So,
it's a PSU lordship under the government
no, it is statutory body, not PSC.
Lordship, I have opened the website lordship.
Ah,
The agriculture process under the Ministry of Commerce and Industry, Government of India. It's a this thing lordship,
No,
just like
it
ONGC.
is a
or-
statutory body. I have seen that. There is an act. So it is not a government of India undertaking, it is a statutory body. There is some difference between statutory body. If government of India has the entire state.
Lordship, that's what.
There is not.
Maximum
under-
shares, yes.
It is statutory body entirely belonging to the government of India. Now it is categorical that 13C. So your argument has to be on that point that we are not 13C. And it may come under 13B. Even in that case also you have 10 employees. That is the only one. 13C.
Yes, my lord.
What to do? Do we?
My lord, if my lord peruses page number 11 of my writ petition.
Page number 11.
My lord, this is the contract of employment.
We have seen.
Para 5, my lord. 5 and 6, my lord.
Merely saying that will not do, this act will override everything. Now here the definition of employee is there. 2E. 2E is there.
Yes, my lord.
Now you have to
Wages.
overcome 2E. There is nothing specific in the 2E that contractual employees will not. If he has rendered 5 years service, then after 5 years service,
It becomes eligible.
it becomes eligible for gratuity. And it is not that this is a beneficial legislation. So, on the findings of fact, how much we can interfere in labor law? That is what the question is. You can show me that yes, we can interfere into that. This finding of facts, you have not disproved by any
Evidence.
statement or evidence that you are 13C. Secondly, he has rendered maybe with some break, but 13 years of service. Your unsatisfactory performance
Leave was.
plea that was without any substance. Right. So whether we can examine any question of fact determined by the controlling authority. Because appellate authority is empowered to reappreciate the evidence. But not to 26 jurisdiction.
They have
What is the
15
law?
they have 15 regional offices, Lordship.
15.
15 in Mumbai, Bangalore, Telangana, Kolkata, Guwahati, Ahmedabad, Varanasi, Chandigarh, Bhopal, Chennai, Kosi, Tripura, Srinagar, Jammu and Ladakh.
And you are fighting for 60,000. Is it not? Come to Annexure C of the affidavit in opposition of respondent number 1 and 3. Yes. I pick on. I pick.
In fact, Annexure C and Annexure B, Lordship. Services expenses will be paid to them.
So you have denied him to sign attendance register also. So why contractual workers are not entitled for gratuity?
Because the terms of the employment does not state so, my lord,
But you have to decide it on the basis of the definition given.
payment of labor.
Definition given of employees, wages, clear.
Fact, Lordship, for the definition, whether the terms of such employment are expressed or implied. In fact,
Here it is expressed already.
yes,
That is the only requirement.
yes, yes. And it could be a shop also, Lordship,
Yes.
company or shop. But does not include any such person who holds a post under the central government or a state government and is governed by any other act or by any other rules provided. No, Lordship, he's just a peon, Lordship. Squarely covered under the definition. Lordship.
Yes, how far we can go in 226 proceeding?
Agriculture process, free product development.
What is the layman?
Oh, yes, is a necessary party.
We are,
This is case.
it is his case.
It is his case.
He has filed an affidavit,
Yes, madam.
right?
Yes, madam.
Yes. What is the provision for exemption? Only thing is that 1(3)(b) and 1(3)(c), I am only on it. Because 1(3)(c) says such other establishment. Such other. As the central government may by notification specify in this behalf. So there has to be notification of the central government that this establishment
Falls
comes
under
under
payment of
this act. Right? Or otherwise, 1(3)(b). There I am concerned with only two things. In a state,
So in our state only.
that is that what interpretation is to be given. In a state. That particular, only that issue is required.
No matter how the learned controlling officer came to the finding that we are covered under 3(1).
We don't know.
That's questionable, my lord.
You have not questioned it also. You have not questioned it also. In the entire writ petition. You are not questioning. And second thing. This claimant, he says you are 13A. Now, three things here. Controlling authority says you are 13C.
Yes.
You want to claim you are 13B. And the claimant says 13A.
1(3)(a) won't be applicable, my lord, because factory, mine, oil field, plantation, port, and railway company. We are neither of these.
But here's a factory.
And my lord, one more thing, my lord, section 4, payment of gratuity, my lord.
Hmm.
The three conditions are there, my lord. On his superannuation, on his retirement or resignation, on his death or disablement due to accident or disease.
But it was a vindictive termination. Vindictive termination, illegal termination, but unsatisfactory, your order says unsatisfactory performance and stealing of so and so. And ultimately you raised a plea and it fell apart before the controlling authority.
There was
So
no
this-
renewal of the contract, my lord.
It come within the purview because he has been prevented by wrongful means. It appears before the controlling authority that you, that annexer of your document, of that affidavit annexed by this
1 and 3, my lord.
1 and 3 somewhere. I have
Annexure
seen.
C.
I have seen somewhere. Page 23. Contract was terminated. Terminated due to unsatisfactory services and stealing of documents. And this is also contradictory. See the statement, page 23. This letter, 1st November 2012. It is submitted that Mr. Bormon was a contractual worker engaged on 6-monthly basis whose contract was terminated. Terminated, right? Due to unsatisfactory services and stealing of documents from the regional office of APEDA, even when he was not under the contractual agreement which was brought to your notice in our last meeting. So he was terminated. Thereafter, you have brought an allegation that after, when he was not in employment, he stole it. Yes, tell me how, what is the ambit of, we'll record the facts. If you are not able to tell me on the ambit and scope, I'll find out. Otherwise, we are not disturbing the determination of facts by the controlling authority. Come up with something. We're fixing our seventh. Right. But we'll dictate the factual part. The instant repetition is under Article 226 of the Constitution of India is preferred to assail an order. Take your seat. Let me narrate the facts. Order dated
1,
12,
12,
11, 2012.
12.
Passed by the Assistant Labor Commissioner within bracket Central, Government of India, Guwahati, in his capacity as the controlling authority under the Payment of Gratuity Act from 1972. By the said order dated 12/11/2012, the controlling authority has held that the applicant therein, i.e. the respondent number 2 hearing, is entitled to get gratuity and holding so, has directed the appellant, the opposite party therein, i.e. the petitioner, that is the petitioner hearing, to pay an amount of rupees 68,000 to the applicant within bracket the respondent number 2 as gratuity plus interest within a period of 30 days from the date of receipt of the order stroke direction. Full stop. The order stroke direction dated 12/11/2012 was forwarded to the parties, the copies of the was forwarded past controlling authority in application number colon PZ stroke 48 within bracket 01 stroke 2012 dash C stroke 8 epithet. The copies of the so and so were forwarded to the parties by the office of the Assistant Labor Commissioner Central, Guwahati, filed a communication bearing number is 16 dated 14/11/2000. The proceedings of application number PZ stroke so and so was initiated by the controlling authority on receipt of an application in form quote unquote capital N dated 31/8/2012. Under Rule 10 within bracket 1 of the Payment of Gratuity Act, 1972. Before the controlling authority who is empowered by the provisions of Section 3 of the Payment of Gratuity Act 1972 for administration of the Act. In the application filed in Form N, the applicant mentioned that he was an employee under the employer, Messrs. Agricultural and Processed Food Products Export Development Authority at its Guwahati office. Would you make it repetition? The repetition. At its Guwahati office from 6/10/1998 till 31/12/2011 with full stop. The applicant in his application had mentioned that he was terminated by the management after rendering service under the employer for a period of 13 years and 3 months. Full stop. contending that he is eligible for gratuity under the Payment of Gratuity Act 1972. The applicant made a claim for a gratuity amount of rupees 63,000 in the said application. Custom. It transfers that it is noticed that come to page 24 of their affidavit. It is noticed that the applicant, that's respondent number 2, submitted an application before his employer, that is, Messrs. So in so naam to দিব within bracket, after referred to as, what is the short form? APFPEDA. APFPEDA for short, for the purpose of brevity. Claiming gratuity. When it was thereafter, the respondent, the applicant, that's respondent number 2 filed the application in form N before the controlling authority under Rule 10(1) of the Payment of Gratuity Central Rules 1972 for issuing a direction under subsection 4 of section 7. Para. To come back. In the meantime, we'll try to find out ambit and scope of 226.
তোমালোকৰ এইটো হয়, এইটো 1600 নিচিনা আছে, তোমালোকে market টো পাই যাব, চব লাগে এইবিলাক।
Actually, বহুত ধুনীয়া আহিছে। তুমি এতিয়া looking নহয়, এনেকে উকি থাকিলে মানুহ ধৰি ইয়াত আমাৰ কাম কৰি আছে।
নাই, নিজৰ পাইছে।
60,000 ত বিক্ৰী কৰি ঠিক নাই লাগে। এইটো নহয়।
তেওঁলোকৰ employees কেৱল আছে।
और मैं चीजें ऐसी चीजें तो जरूरी है ना
Release तो मुझे लगे, देखो release ना लगे। उसका तो मुझे इस बात लगे। हाँ, लेकिन
आपको पूरा लेके रसिक को लेकर अगर तो मैं तो बोले तो सामान
तो कोई मेरा सजेस्ट कर रहा है कि देखो सम तो दिया सब में बैठ के देखो तो एक मन बोल सो हम लोग को दिया सब तो सो नंबर 2 रिलीज करा है
ये 60,000 की ही थी वो आपको चैनल में वो ये गांव से तो क्लियर हो लगे ये ट्रैक पे आपको काम दे रहा है ये है देखिए वही हम देखिए तो मसले से ही काम है सिर्फ पब्लिक से देखिए तो ये देखिए रिकॉर्ड है रिकॉर्ड है वापस है मतलब से तो वो
हमें लीगल सर्विस अथॉरिटी को
सर में लोगों से पूछ ले बोला वो बोल लेकिन वो अब देखिए ये लॉ की बोलते हैं अपने को कैसे चलाओगे ये कैसे दिखे आपको मैं ले आओ ये बोल अपने के लिए कुछ है वो एग्रो से काम करेंगे ना क्लियरनेस
नहीं बच्चों लगे तक क्या चल रहा है इनसे कंप्लीट आप बताओ सारा
एक्सेप्ट क्लियरनेस संपूर्ण एप्लीकेशन यूजर लॉग में
फिर नाइस के
अंदर अभी ने क्यों इसे स्टार्ट करके
आपसे फिर से बोलूंगा तो
सूल स्किल अब लोग सेटल भी
मैं तो आपका कहने लेकिन है हमारा एक्टिविटी में लेके लेके हाँ
वो पर वाले सब नेक्स्ट टाइम को चाहे
क्योंकि रेफिडेंसी का नेक्स्ट टाइम
एक्चुअली कार मुझे दे दिया मुझे रिव्यू से आने के टाइम जो मान लो
इससे बाहर वो पूरा हो जाता है यहाँ पे एक्सपेंसिव हो रहा है होम नॉलेज की साहब होम नॉलेज क्या एक्सपेंसिव
This might have some consequence. That is why section 1 to B and 1 to C is there some consequence. That is why I'm trying to find out what is the exact interpretation. And Mr. Borua, if I dictate any disputed fact, then we are not, we're dictating only the established facts,
my lord.
leaving it for you to make submission
My lord.
on the disputed fact. On receipt of the application from the applicant respondent number 2 in form N, comma, the controlling authority registered the state application as application number so and so. For determination of the dispute under subsection 4 of section 7 of the Payment of Gratuity Act 1972. Full stop. As per subsection 4 of section 7 of the Gratuity Act, Payment of Gratuity Act 1972, comma, the controlling authority shall, comma, after due inquiry and after giving the parties to the dispute a reasonable opportunity of being heard, comma, determine the matter or matters in dispute. And if, comma, as a result of such inquiry, any amount is found payable to the employee, comma, the controlling authority shall direct, is empowered to direct the employer to pay such amount, or as the case may be, comma, such amount as reduced by the amount already deposited by the employer. Post. Under the provision to sub-rule 1 of Rule 10 of the Payment of Gratuity within bracket Central Rules 1972, comma, the controlling authority, comma, in an appropriate case, comma, may accept any application under Rule 10(1), comma, on sufficient cause being shown by the applicant, comma, after the expiry of the specified period. Full stop. The controlling authority admitted the application, accepted the application for hearing after considering the delay is sufficient of the application on the ground that the Payment of Gratuity Act 1972 being a social welfare legislation, is meant for working class people. And for ends of justice and fairness. Full stop. Notices in Form O were thereafter in Form O as per sub-rule 1 of Rule 11 of the Payment of Gratuity Central Rules 1972 were issued to the parties for their appearances before him to decide the matter of dispute under Section 7(4) of the Payment of Gratuity Act. Those upon receipt of notices, both the parties appeared before the controlling authority. Full stop. The petitioner was represented by its Assistant General Manager and the applicant as respondent number 2 had appeared in person and made his submissions. Full stop. The hearing on the application was concluded on 5/11/2012, and thereafter, the impugn order was passed on 12/11/2012 by the controlling authority with the order stroke direction, mentioned above. Full stop. Before the controlling authority, the applicant as respondent number 2 submitted his letter of appointment dated 28/9/1998 and a letter dated 8/7/2011 issued from the end of the employer to claim, to substantiate his claim regarding his employment under the APEDA. Full stop. It was represented that his employment during the period from 28/9/1998 to 31/12/2011 was continuous and or with some intermittent breaks. Full stop. It was contended that at the time of retrenchment, at the time of his retrenchment by his employer, comma, the applicant respondent number 2 was drawing monthly wages at rupees 8,400 per month. Full stop. It was represented before the controlling authority by the applicant that's respondent number 2 that his employer deliberately engaged him on intermittent basis with a short break in service in between 2 contract periods, with a view to deprive him from the various benefits accrued under the beneficial legislations, socially beneficial legislations like the Payment of Gratuity Act, though the works performed by him was perennial in nature. Full stop. It was contended that as he had rendered about 13 years, 3 months of service under the employer, it was clearly evident that the nature of work was perennial in nature, and the employer had unjustly denied him regular employment. Full stop. The contentions of the applicant, that's respondent number 2, were refuted were sought to be refuted by the authorized representative of APEDA before the controlling authority, with the contention that the applicant as respondent number 2 was terminated due to unsatisfactory performances and stealing of documents from the regional office of APEDA regional office APEDA at Guwahati. Full stop. It was contended that on examination of the application, submitted by the applicant, that's respondent number 2, for eligibility of gratuity, the applicant, that's respondent number 2, was found ineligible to receive gratuity under the law, under the extant law, rules and regulations for the region that a contractual worker or who was engaged on 6 monthly basis and whose contract was terminated due to unsatisfactory service, comma, was not eligible for payment of gratuity. Full stop. Having the controlling authority to decide the dispute, comma, had framed the following questions for decision. Page 18, 1, 2, 3, 4, bold or not. As regards the first question, comma, the controlling authority had reached a finding that the APEDA under the Ministry of Commerce and Industry, comma, Government of India, is an establishment under the provisions of section 1(3) within bracket C of the Payment of Gratuity Act. Full stop. As APEDA did not have any other scheme of payment of gratuity or pensionary benefit not less favorable than the benefits provided under the Payment of Gratuity Act 1972. Comma. It was held by the controlling authority that the provisions of the Payment of Gratuity Act 1972 would be applicable in the case of the applicant. That's response number 2. Full stop. As regards the second question, comma, the controlling authority had referred to the provisions of section 2(e) of the Payment of Gratuity Act to hold that the applicant, that's respondent number 2, being a person employed on wages, comma, could be eligible was eligible as an employee to receive the benefits of gratuity under the Payment of Gratuity Act 1972. Full stop. The controlling authority had also reached a finding that the applicant, as respondent number 2, had rendered more than 5 years of service in terms of the provisions of section 4 of the Payment of Gratuity Act 1972. Full stop. Para. With by answering question number 3 in that manner, comma, the controlling authority had proceeded to calculate the amount of gratuity for answering question number 4. Full stop. The controlling authority took the length of service of the applicant dash. Response number 2. As 13 years for the period from 6/10/1998 to 31/10/2011 and accepted rupees 8,400 per month as the last wages drawn by the applicant as respondent number 2. Full stop. With such figures, comma, the controlling authority had found the total entitlement of gratuity of the applicant as rupees 63,000 within bracket equal sign rupees 8,400 multiplied by 15 multiplied by 3 divided by 26 bracket close. Full stop. As the controlling authority found that the amount of gratuity, comma, rupees 63,000 was payable on 31/1/2012 on termination of service of the applicant as respondent number 2 by the employer, and the gratuity was and the same gratuity amount was not paid, comma, thereby delaying the payment by 10 months from 31/1/2012. The date, that is the date of becoming due, comma, it was held that the employer would be liable to pay interest at 10%. Liable to pay simple interest at 10% as per the provisions of section 7(3) of the Payment of Gratuity Act. Full stop. Thus adding the interest component of rupees 5,250 with the amount of rupees 63,000, comma, the controlling authority has made the direction to the employer, that is APEDA, to pay an amount of rupees 68,250 to the applicant as respondent number 2 as gratuity plus interest within 30 days from the date of the orders to direction. It was agreed by the said order stroke direction dated 12/11/2012. The employer, Messrs. APEDA, has instituted the instant writ petition seeking setting aside of the order stroke direction dated 12/11/2012 passed by the controlling authority in application number so and so. Yeah. Yes, what are your contentions? Heard Mr. K.R. Barua,
Care of-
learned counsel for the petitioner.
First contention is that, my lord, it is a contractual.
And
appointment.
Mr. C.K.S. Burwal under Central Government Council for the respondent number 1 and 3. Full stop. এইটো টু চাই ল'ব লাগিব নেক্সট ডেটত নাহিলে ঠিক কৰিব লাগিব টু এনে টেষ্ট মাৰি Yes.
First contention is that, my lord,
Hmm.
the appointment being a contractual appointee is not liable to the benefits of.
Mr. Borua, Learned Counsel for the petitioner has submitted that EPEDA is an authority under the Ministry of Commerce and Industry, Government of India, and it is established under the provisions of the Agricultural and Processed Food Products Export Development Authority Act, 1985. Full stop. After referring to the aims and objects of EPEDA, Mr. Borua has contended that EPEDA had a small office at Guwahati where only two officers appointed on regular basis, were deployed. Full stop. He has contended that the respondent number 2 was engaged on as peon on contract basis on 6/10/1998.
Yes.
And in the appointment letter, it was made clear that once the contract period would be over, his service would come to an end. Full stop. He has thus, full stop. He has, however, submitted that the respondent number 2 was periodically appointed on contract basis on consolidated pay with a break in between. So initially the break period was for 1 or 2 days, but subsequently the break period became longer. Full stop. The last contractual appointment of the respondent number 2 was with effect from 8/7/2011 to 31/12/2011. So thereafter, the authority decided not to have any contractual employee. And as a result, the contractual period of the respondent number 2 was neither extended nor renewed. Full stop. He has contended that the respondent number 2 cannot be termed as an employee within the definition provided in Section 2E of the Payment of Gratuity Act 1972. His further contention is to the effect that, yes, next contention.
My lord, section 1(3). I fall under section 1(3)(b), my lord.
Since only 2 regular employees were serving in the Guwahati office of EPEDA at the relevant point of time, the provision of provisions contained in section 1(2)(b)
One
of the
three, madam.
Payment of Gratuity Act,
1(3).
1(3)(b) ought to have been made applicable. Full stop. Any other?
Madam,
That's true. Yes, Mr. Borua. Record your submission and.
So my submission is from pair number 11 of the affidavit of opposition.
Mr. Borua. Now, the Central Government Council. Representing the respondent number 1 and 3. Has. Objected to the submissions. Made on behalf of the petitioner. Full stop. He has contended that admittedly, the respondent number 2 was engaged by APEDA on contractual basis, maybe with intermittent breaks, during the period from 6/10/1998 to 31/12/2011. Full stop. It thus clearly indicates that the requirement, there was requirement of an employee in the post of peon at the party office of APEDA perennially. Paragraph.
Paragraph 12, last
Paragraph?
part, paragraph 12, last part, Lordship.
Huh?
Paragraph 12, last part,
Paragraph 12.
12, last part, Lordship, that will be in internal page number 8. Though he had initially rendered continuous service of more than 3 years, mandatory 240 days of job to accrue benefit under the provisions of the Act.
Paragraph 12 for what? Paragraph.
Paragraph 12, last part, Lordship, that will be in the internal page number 8. To accrue benefit under the.
It was found that the respondent number 2 had initially rendered continuous service of more than 3 years. That is, mandatory 240 days of job to accrue benefits under the provisions of which act?
Lordship, this payment of gratuity act, Lordship.
Wherefrom you are saying that this is maintainable under the provisions of the Payment of Gratuity Act. And thereafter, he had rendered further 10-year service under APEDA. Full stop. Before during the course of hearing before the controlling authority, the authorized representative of APEDA had submitted that the services of the respondent number 2 was terminated due to unsatisfactory performance and stealing of vital documents from its office. But the said fact could not be substantiated by the employer of the respondent number 2. Full stop. Thus, such projection was made clearly with a view to deprive the applicant number, respond number 2, to get the benefits under the social welfare legislation, comma, the Payment of Gratuity Act. I am given due consideration to the submissions advanced by the council for the parties. And I have also used the materials brought on record by the parties through their meetings. Full stop. The Act, comma, the Agricultural and Processed Food Products Export Development Authority Act 1985 has been enacted by the Parliament to provide for the establishment of an authority for the development and promotion of exports of certain agricultural and processed food products and for matters connected therewith. Full stop. The provisions of the Act had come into force WUF 13 to 1986. Full stop. Section 4 of the short form Act 1 APFPEDA Act. Section 4 of the so and so Act has provided for establishment and constitution of an authority. Full stop. As per subsection 1 of section 4, comma, with effect from such date as the central government may, comma, by notification in the official gazette, comma, appoint in that behalf, comma, there shall be established for the purpose of the Act, comma, an authority to be called the Agricultural and Processed Food Products Export Development Authority. Full stop. As per subsection 2 of section 4, comma, the authority shall be a body corporate by the name aforesaid, comma, having perpetual succession and a common seal, comma, with a power to acquire, comma, hold and dispose of property, comma, both movable and immovable, comma, and to contract, comma, and shall by the shade name shew and be sued. Full stop. The head office of the authority shall be at Delhi, and the authority may, comma, with the previous approval of the central government, comma, establish offices or agencies at other places in or outside India. Full stop. Thus, comma, the petitioner, thus, comma, Messrs. Epedanaki, full form, short form, is an authority established under the Act BIZ, full form to and is a statutory authority. Full stop. With its head office at Delhi, comma, Messrs. Epeda can establish offices or agencies at other places in or outside India, comma, with the previous approval of the state central government. It is since it is an admitted position. The repetition has ever that it had a office at Guwahati. It can be easily inferred that the establishment of the office of APEDA at Guwahati is in conformity with the provisions contained in subsection 3 of section 4 of the so and so. That amount was directed.
My lord,
Deposit.
deposit in the registry, I guess. I'm not sure, my lord. I'll have to confirm.
You have not gone through. I have seen one page somewhere. Yes, yes. Fifteen 2013 was deposited. 68,250. I think 25th February 2000. Entire amount.
Yes, my lord.
68,250.
Deposit. Deposit.
Post. Where?
Page. Page.
20.
Page.
From the documents appended to the affidavit of position of the respondent number 153. It is noticed that the by and appointment letter dated 28/9/1998, the respondent number 2 was engaged in the post of peon by the Guwahati office of APEDA. Not Guwahati office, right? Issued under the hand of the deputy director, APEDA, for the period from 6/10/1998 to 5/1/1998 at a consolidated amount per month as service charges. First of all, it was mentioned herein that the association, such association with APEDA would not constitute an employee-employer relationship, and APEDA would be liable only to make payment for the services rendered. First of all, the said appointment letter was followed by a number of other engagement trouble. Number of other letters of engagement, comma, dated 1/1/1999, comma, dated 8/4/1999, comma, dated 20/07/1999, comma, dated 9/9/1999, Six, 2001. From the said letters of engagement, comma, it is noticed that the respondent number 2 was in continuous engagement with APEDA from 6/10/1998. To 9/11/2001. Full stop. So you were deducting PF.
Nala?
You were deducting PF. Come to page 22. A provident fund also. Page 22 of their affidavit. Provident fund. While answering question number 1, command the controlling authority had observed that at the time of retracement of the respondent number 2 by AFEDA, comma, the respondent number 2 was drawing monthly wages at rupees 8,400 per month. Full stop. The controlling authority had recorded that that AFEDA did not contradict the particulars of the date of appointment stroke intermittent employment and large wages drawn by the applicant respondent number 2, as the documents were the matter of proof on records. Full stop. The controlling authority had reached a finding that the employer, comma, APEDA বুলি কৈছো মই, সম্পূৰ্ণটো চাই লব, APEDA মই কৈ আছো এটা স্থিৰ কাৰণ, had deliberately engaged the applicant respondent number 2 on intermittent basis with a short break in service in between 2 contract periods with a view to deprive the applicant does respond number 2 from the various benefits accrued from the socially beneficial legislation like the Payment of Gratuity Act 1972. Though the works performed by the applicant that's respond number 2 was perennial in nature. The controlling authority had also recorded the finding that there was sufficient nature of work in the establishment of APEDA to employ the applicant as respondent number 2 on regular basis, as the applicant as respondent number 2 was employed with APEDA for a considerable period of 13 years, as per records available on Merit. Poster. The contention of the employer that the applicant as respondent number 2 was terminated due to unsatisfactory performances and stealing of documents from the office of APEDA was discarded by the controlling authority. As APEDA, as the employer, could not submit any documents regarding unsatisfactory performances of the applicant as respondent number 2, nor any proof regarding stealing of any official documents. Full stop. The contention of the employer, APEDA, as regards ineligibility of the applicant, that's respondent number 2, to receive gratuity was also discarded on the ground that with a finding that APEDA and the Ministry of Commerce and Industry, Government of India, is an establishment belonging to, or under the control of, the central government, having branches in more than one state, and covered under the provisions of Section 13C of the Payment of Gratuity Act 1972. As APEDA, as the employer, did not have any other scheme more beneficial than the provisions of the Payment of Gratuity Act, the controlling authority had found that the provisions of the Payment of Gratuity Act 1972 were clearly applicable for an establishment like APEDA. On 7th, heard Mr. K.R. Council for the petition, and Mr. C.K.S. Goral and Central Government Council for the respondent 1, 2, 1 and 3. As the Learned Council for the respondent number 2 is found absent today on call. Who is the council? Names are appearing, right?
Lordship. Names are there.
And
And
Chakraborty, A Mount of Egg Mount. Okay. On absent today on call, place the case on 790.
Are in the hearing column, hearing column.
The though the learned counsel for the petitioner and the respondent number 1 and 3 are heard at some length, the learned counsel for the respondent number 2 is found absent beyond call. Full stop. List this case on 7/9 for further hearing. Only that much later respond.
No,
number two also
Andhra
come.
Andhra is out of Assam.
Huh?
Andhra is out of Assam.
But there are other names. And who is the counsel in item number 16 then?
16, we have different for
Different
respondent,
set of counsels.
respondent to different, I mean, correspondent to different set.
You are the petitioner there.
Yes,
That is under what? Industrial Disputes Act.
industrial list.
Okay.
Plus versus
Then you find out the scope, ambit and scope of 226 in the absence of preparing an appeal.
My lord.
How far the read court can go into examining questions of fact which have already been determined by the controlling authority.
My lord.
Whether the read court can reappreciate the factual determinations recorded by the original authority. That is.
Yes.
It's 16 to 32. 16 to 32. That might go. Good. I like that. Good, good.
In respect to item number 2, Lordship, I am paying for some accommodation today. But
Why?
the learned counsel A. Sharma was supposed to argue this matter, but he was inside the court also. He left the court due to some medical emergency. Lordship.
What is the subject here?
Lordship, in this case, we have challenged the award passed by the labor court, Lordship, regarding we have dismissed the workman, Lordship, and accordingly they have raised an industrial dispute, and accordingly the learned labor court has directed reinstatement along with the full back wages. Lordship. Next Tuesday or Thursday.
All these are 2013
Yes,
matters.
Lordship, it is
Somehow.
25
If
years
some
past.
difficulty on his part,
25 years,
I will.
1999.
If some difficulty on his part, I will argue it on the next day. Lordship.
That first. 7/9 electoral obligation is on. Able to mandate. 7/7.
Seven. Obligation.
On the prayer of Mr. K. Kolita, learned counsel for the petitioner. Mr. K. Kolita, learned counsel for the petitioner has submitted the arguing counsel. Mr. A. Sharma has some personal difficulty today, so he has thus prayed for some accommodation. So Mr. V.K. Bhagavati, learned counsel for the respondent.
Lordship.
Respondents, no?
Respondents.
Is in attendance, as sought for by Mr. Kolita, learned counsel for the petitioner, lays the case on 7/9.
Interim may continue. Lordship.
Interim.
Yes.
Interim. It is,
Lordship.
yeah.
This time maybe for about you. Continue. Serial, two whole one mention. Hello.
Permits me. Are item number 5, Your Worship. So my shop was closed since 9 months, Your Worship. Will it be permits today, Your Worship, to reach?
Hmm?
Is it possible to reach the item number? I don't know because part of matter is there, others matter.
Part of also there are 2006 writ petitions,
Lordship, that,
which are fixed at two.
therefore, Your Lordship, if I'm mentioning the permission of the report. If, item number 5, I'm hopeful that item number 5 is nearest to the list, so it will reach. But
Yes.
it's not possible, I have to say. So is it possible to fix on 30th of August?
30, 30.
30, Lordship. Wednesday.
Okay, 30.
My urgency is not, my scope was closed for 9 months ago. That is my urgency.
Every cases are this.
Yeah, that-
In this
that's good.
2006 matter, these are lands which have been forcefully taken by the state since 1986.
Lordship.
So those matters have also urgency. Lands taken, your shop,
Shop was closed.
that Adabari bus station lands
Lordship,
are taken.
compensated, Lordship.
No,
Lordship.
but there, suppose you have a land, lot of land, which
Yes.
is taken over by the state forcefully for 30 years
Yes,
without any money.
absolutely.
Those are also important.
Therefore, your
Okay.
Lordship.
On the request of Mr. B. Dottal, Senior Counsel for the petitioner, list the case on 30.
Item number 5.
3008/2023.
Lord.
May I Lordship? And we excuse Lordship, similar situation, my Lord, item 11, 12 and 13, my Lord.
11, 12 and 13 years.
My Lord, maybe some other day, my Lord, subject to your Lordship convenience, my Lord.
2015.
15 matters, my Lord.
What is the subject?
My Lord, there is fixing of seniority, my Lord. Fixation of
Fixing of seniority.
seniorities, fixation of seniorities. my Lord.
Under labor law.
Against the order passed by the labor code, madam.
Okay, on the prayer of Mr. M.U. Amit, Learned Counsel for the petitioner. The cases are adjourned for a week. Office to list the case on a date to be fixed by the office. Any counsel for the petitioner? Petitioner, you are for the respondent,
I'm for the response.
Learned Counsel for the respondent, huh? Who is for the petitioner?
Deepak Day, madam.
He is available.
He's not available now.
Was he sitting in the first half?
No, madam. I'll try to contact him. I have phone number, madam. I have a contact number, madam. I will work on madam. Kindly, madam, the date may be fixed, madam. If possible, madam.
After a week,
After we oblige.
You are in item number?
He's there.
Okay, he has sought adjournment for a week. Mr. D.K. Day, Learned Counsel for the petitioners. He is present. There is no objection to say. Yes, 2013.
Oblige.
What is the subject here? We'll just have a glance and we'll. Mr. Ghosh,
My lord, here in this case, my lord, petitioner is a housing cooperative society, my lord. Registered under the Cooperative Society Registration Act. In the year 1996-98, while the construction was going on, the establishment was covered illegally under the Employees Provident Fund, Miscellaneous Provisions Act. Then we preferred appeal also, no, nothing happened. Then we filed writ petition before this honorable court, and writ petition hold that there is no jurisdiction to entertain to cover this establishment under this act, because under the section 16 of the EPFO Act, there is a provision that if a cooperative society may the section 16 act not to apply to certain establishment. This act shall not apply to any establishment registered under the Cooperative Societies Act
or under any other law for time being in force in any state relating to cooperative societies employing less than 50% and working without aid of power. So ultimately that proceeding was challenged before this honorable court, and this honorable court set aside at page order at page, my lord, annexure 2, page 24 starts from page 24. It is from 23. Page 24 is the order. The petitioner is a cooperative housing society registered under the Assam Cooperative Societies Act. So and so, the cooperative society has been found for the purpose of acquisition of land and construction of residential flat. The construction is undertaken through different contractors at different point of time. The Assistant Provident Fund Commissioner by order dated so and so in exercise of power under Section 7A of Employees Provident Fund Miscellaneous Provision Act 1952 directed the petitioner society to deposit a sum of rupees so and so as provident fund due to the worker employee by during the period from November 96 to March 1998. So and so it is the argument. Datta argued that petitioner is a registered cooperative society under the Assam Cooperative Societies Act 1949, and the person employed for the purpose of construction was less than 50 and no power was used. Therefore, the provision of this Act of 1952 are not applicable in respect of the petitioner cooperative society. For better appreciation, the provision in subsection 1 of the section 14 are quoted below that I have read already. It would appear from clause A that establishment registered under the Cooperative Societies Act 1912 or under any law for time being in force is exempted from payment of provident fund in respect of employee if the number does not exceed 50 and they do not use power. In the instant case, the certain point of time, the worker of employee by the contractor exceed 50, and this situation, as it appears, led the Assistant PF Commissioner to direct the petitioner society to deposit provident fund. The order passed by the Provident Fund Commissioner Annexure 3 nowhere reflects that the person employed by the petitioner society were working with the aid of power. Even the inspection report on the basis of which the impugned order was passed also does not reflect that the employees were at any point of time required to work with aid of power. The authority empowered to collect the provident fund dues will have to satisfy himself of this requirement while directing the cooperative society to deposit the provident fund dues, that it has its employment either directly or through contractors. Worker exceeding 50 and that they have been working with the aid of power. If it is found that number of workers exceed 50, they are required to work with the aid of power. Only in that case, Commissioner may invoke the provision of this Act. In the instant case, requirement of law as required under the provision of Section 60 are not complied with. Therefore, the impugned order dated so and so is liable to be set aside and quashed. So after passing of this order, we file an application for refund of the money. And
Oh, you have deposited that.
one part deposited, another part they are attached the bank account. By attaching, there is a power, my lord. By attaching the bank fund, they have realized the amount. Then kindly see page annexure 4, my lord. Page 28. To the additional, this is the letter written by the regional PF Commissioner to the additional central PF Commissioner zone. Refund of deposit amount so and so. I am to inform you that Honorable High Court has passed the order in WBC number so and so, quashing the impugned order under Section 7A dated so and so. The implication of the judgment is that the concerned establishment so and so goes outside the purview of this Act till 5/10/1998. Following this judgment, this establishment has requested for refund of money which establishment has deposited, and this office had recovered. A gist of the issue involved is given below. Establishment was covered under including head of building construction with 20 employees with effect from 11/1996. An order under section 7A dated so and so was passed assessing the dues for the period of 1996 to 1998. In the said order, payment of rupees so and so by the establishment was recorded. Copy of 7A enclosed. A recovery of rupees so and so was further recovered as per the file. Again, the recovery proceeding, the establishment had filed a writ petition. The outcome of the case has been judgment of Honorable High Court dated so and so, quashing the order under section so and so. Citing the court order, the establishment has requested for refund of the amount deposited. In this regard, legal opinion was sought for from standing counsel. The legal opinion quashing of the 7A order put to an end to cover of the establishment till 5/10/1998. The High Court quashed the order cannot be appealed now, both the legal ground as well as point of liquidation. The judgment is silent about the refund of the money. This is the important. However, legally speaking, such amount deposited is otherwise liable to be refunded since the foundation of such deposit has been declared null and void. Unless a clear demand for refund is lodged by the establishment, such refund is not to be given. Covered beyond after 5/10/1998 is not barred. In the circumstances, legal opinion of the highlighted above, it is for your kind order and advice, the refund of deposit recovered amount to the establishment with interest rate to codify the establishment as 103. Then, my lord, when this process was going on, they issued another notice under section 7A again. Next page, page 29.
1 minute.
Without refunding, they issued again section 7A notice, page 5, which is under challenge.
Yes.
Next page 29.
Yes, Chief. Hmm.
Now, without refunding, nothing. Then 11/4/13. This again, same notice was issued. Notice under section 7A of the Employees Provident Fund and miscellaneous provision at 1952 in respect of so and so. Whereas inquiry under section 7A of the Employees Provident Fund in so and so was initiated against EU establishment, and a speaking order was issued on 26/6/1998, which was quashed by the Honorable Guwahati High Court by the order dated so and so, on the ground that while passing the said speaking order, the assessing officer did not examine whether the establishment employing 50 or more person was working with or without the power. But this is important, but the Honorable High Court has not commented on applicability of the Act. Now, to determine the applicability of the Employees Provident Fund miscellaneous provision so and so, notice under section 7A of the Employees Provident Fund miscellaneous provision 1952 is issued to your establishment, and you are directed to appear before undersigned on so and so with all relevant documents in connection with the employment strength at your establishment to determine the applicability of EPF Act so and so. Then immediately we have filed a reply, and in reply we are saying so that it is a housing society, there is no employment generation, and number two, you have no jurisdiction. Regarding jurisdiction point, we have raised in next page, page 30.
Yes.
With due respect, humbly submit as follows. That, my lord, before going to this reply, my lord, when earlier the proceeding was going on, we have filed appeal. There was a provision of appeal also, under section 7C. That was not attended by the department, but during course of the proceeding before this Honorable High Court, they make an inquiry. That inquiry report I obtained through RTI and submitted through additional affidavit. That report kindly be, it is very much essential for determination, my lord. That report I have annexed
By way of,
by way of additional affidavit, starts from page 50. Running page 50.
yes,
That document at page starts from page 60.
page
60. This is department has examined the matter.
Annexer,
Annexer, my lord, it is annexer. Page 60.
60.
Annexer 14,
59.
58, annexer 14. Type
Annexer 14, yes.
Annexer 14. Here they have done investigation how this establishment covered under the EPFO Act. During investigation, my lord, kindly see analysis of the document page 60 from page 62.
Report, I think, starts at page of the 60.
My lord, I will read shortcutting. I will concluding part. I allow to read, my lord. Conclusion, page 65. Page 65.
Conclusion, yes.
Yes. The allegation labeled by so-and-so against Vikas Roy EO that later managed to bring the establishment under EPFO ME Act 52 for his personal gas thus does not appears to be totally false. During investigation, it could be gathered that Sri Vikas Roy EO purchased a flat so-and-so from the society during 1996-97 at a cost of rupees so-and-so. At the time of purchase of the flat, Sri Roy was posted as EO NER at headquarters, that is in Guwahati. Besides Sri Roy, some other officials also have purchased flat from this society. However, the way the establishment was covered on the basis of reports submitted by the squad of EO and the subsequent quasi-judicial proceeding initiated against the establishment is an indicative of making some design by the official of regional officer NER. It is also true that the official who played a key role, including Sri Vikas Roy EO and Sri NK Dev APFC, it is observed that Sri Roy along took keen interest in collecting information about contractor workers. In one such document, it is observed that Sri Roy himself prepared the investigation report and managed to obtain signature from one Krishna Bala, reportedly a contractor. The report is dubious in nature. Thus, the needle of suspicion about official respondent for the ill design made against the establishment turns towards Sri Vikas Roy. However, he has been aided by other officials in the game, including AFC enforcement Sri NK Dev and the then RPFC 1 regional office NER Sri Rajat Goswami Sri Dev APSC hurriedly completed the 7A proceeding in about 3 months' time, but took 84 days to issue final order. He did not pay any heed to several appeals made. This is important. He did not pay any heed to several appeals made by the establishment for the time and raised doubt about the coverability of the establishment. Sri Dev has therefore acted in such a manner as is not expected from quasi-judicial authority. However, the complaint that Sri Dev and Sri Sen EO demanded bribe from the establishment could not be established during investigation. Recommendation: Headquarters may like to issue suitable instruction to RPFC Regional Office NER to arrange to undertake review proceeding under Section 7C against the establishment in order to have in-depth analysis as to whether the establishment at all attracts provision of so and so for coverage. And this is the report. Then without taking all this document and our submission regarding the jurisdiction of the authority, they passed order, impugned order, that is at page 47.
47.
Annex 13.
Okay.
Whereas the inquiry under Section 7 was initiated to decide applicability of so and so act on establishment of so and so, hereinafter referred to as the establishment, in order to decide the applicability of the act to establishment, and accordingly summon have been issued to establishment by order dated so and so, directing the establishment to appear undersigned on ATO with all relevant records to determine the applicability of the act as provided under Section 7A. Consequent upon the judgment of the Honorable High Court was the order of assessment determining the dues payable by the establishment by order dated so and so. And whereas by order dated, the establishment represent so and so submitted a letter terming such summon to conduct such inquiry as without jurisdiction, arbitrary, malafide, and capricious, and deliberate disobedience of the order of the High Court amounting to appropriate legal consequences, and that such inquiry should be withdrawn, recalled, or otherwise to forbear from proceeding with the inquiry. And whereas by FX letter dated so and so stated to be the elected director of board of establishment added, the fact that the establishment is an employer was to be established first. The employment strength of the establishment was 0. That the fact the establishment was paying any wages directly or indirectly was to be proved. That to prove to proceed with the inquiry, there must be dispute. That the harassment to the establishment by EPO with against the endeavor of the state which promote voluntarily formation, autonomous functioning, democratic control, so and so. And whereas the establishment was one again asked to appear with all relevant record to examine the applicability of the act. On the establishment by this office letter dated so and so, fixing the date for hearing on 28/5/2013. And whereas on 28/5/2013 at about 3 p.m., so and so introducing himself as a director secretary and so declaring himself as a director of the establishment appeared. While enforcement officer appointed under Section 13 of the Act of the represented and department, during the proceeding, Sri Mojumdar, the departmental representative, submitted his finding in the joint squad inspection report dated 27/5/2013. Sri Dilip Dev could not produce salary and wages record of the employer from this date set up to squad enforcement officer who visited establishment on so and so. So it is a housing society. Question of payment of salary, all these things does not arise. Now that so and so stated that as per Section 80 of Assam Cooperative Societies Act, it was not mandatory for them to retain record beyond 10 years. That as per record available in the office, the list of employee provided by the then secretary was 39, whereas as per list provided by them, secretary was only 9. That the establishment had reported compliance by remitting an amount of rupees so and so as area dues and requested by letter dated so and so to allow more time to clear the area dues. And whereas during the inquiry proceeding, the inquiry authority asked the representative of establishment if they had record from the period from which establishment was brought within the purview of this act with effect from 1/11/1996 to this Sri Dev quoted the provision of section 80 of the Cooperative Societies Act 2008-7, which does not make it mandatory to retain record beyond 10 years. But when he was asked again if he had record for the period in question, he expressed his inability to confine the same and replied that it was not sure if anyone had record for the said period. Meanwhile, Sri Representative so-and-so, director of the establishment, replied that they had come to challenge the jurisdiction of the EPFO to conduct such inquiry. When the two was asked if he had knowledge of the record for the period in question with effect from 1/11/1996, he refused to answer, citing the provision of section 80 of the Cooperative Societies Act. And whereas due to non-cooperation of the representative of the establishment, the inquiry authority could not proceed any further and both decided to leave the proceeding mindway. While leaving, so-and-so asked full name of the inquiry authority, stating that he wanted to file contempt against him. And whereas 7A of the Act provides that the Central Provident Fund Commissioner, but any additional so-and-so, any regional so-and-so, by order, in case where a dispute arises regarding the applicability of the Act to an establishment, decided such dispute and to determine amount due from the employer under provision of this Act scheme and so. And for the aforesaid purpose may conduct it with inquiry as he may deem necessary. The officer conducting the inquiry under section so, this is regarding enforcement and all these things. Now concluding part is next page. And whereas as per such provision as stated above, inquiry has the power and jurisdiction to conduct such inquiry to decide an applicability of the Act in respect of the establishment. And whereas due to observe, this is the findings. Now question is, my lord, from 1996 to 1998, that was set aside by this honorable court. So now, once again, how can they reopen that issue again? And under such circumstances, we have raised the objection that you have no jurisdiction to decide such finding after quashing of the earlier proceeding by the Honorable Guwahati High Court. That they have not answered, that they have authority. Rather said that High Court has not commented on it. In the notice, they have said that High Court has not commented on it. And they are as if sitting over the judgment of the Honorable High Court. In the notice, it was clear that High Court has not commented on the applicability of the Act. One hand, they are saying they refund the amount. On other way, without refunding, they are initiating the proceeding by reopening the earlier issue which was settled by this honorable court. So now only question is whether it can be reopened, which was settled by the earlier.
In response to this notice, did you submit anything?
Yes,
Reply.
next page 30,
Page
30. Annexure 6. With due respect, humbly submit, I beg to state follows. Lordship got that an order under section 7A of the Employees Provident Fund is so and so was passed by this office on 5/10/1998 on an erroneous presumption of fact that Act applies to the Puvalia Housing Cooperative Society Limited, a housing society constituted and managed mostly by retired employee belonging to the middle class strata of the society. Since under section 16(1) of the Act, it is prima facie not applicable to our society, we challenge the validity of the said order before the Honorable Guwahati High Court, so and so. And thereupon, the Honorable Guwahati High Court was pleased to quash the proceeding by judgment and order dated so and so. That while the EPFO neither challenged the said order, nor had any reason or basis to do so, except the position, and thus the matter attains finality. Surprisingly, failing to take note of the finding in the said judgment of the Honorable Guwahati High Court, the notice under reference appears to have been issued from your office, though not sought to serve on us by any known procedure of service of summons. Be that as it may, since we have come to know about the notice from the market, understandably a night chowkidar of the neighboring state, we deemed it necessary to submit this reply only to point out that the notice is without jurisdiction, arbitrary, mala fide, and capricious, apart from perhaps being
Okay, to initiate an inquiry under section 7A.
a Earlier
They can simply initiate an inquiry, or they have to reach a prima facie satisfaction that what is the
yes,
condition precedent
condition
for initiation of an inquiry under section
Seven.
7A,
a, yes,
right? Whether they have to reach any prima facie satisfaction, right? That there is a dispute as to whether these provisions are applicable to this particular establishment or not. At least they have to have prima facie satisfaction. More particularly because of the order already passed by the High Court.
Yeah.
Whether they had any reached a satisfaction, whether they have mentioned anything.
no,
Huh?
no, nothing. My lord, may I read 7A?
So what is impugned? Page 29 is impugned.
Impugned is page 29 and this actually page 29, and the order, it has not been the pass at page 47. That is regarding jurisdiction point only decided that they have created
7.
47. 13.
What they have said?
They have said that last page 49, and whereas as per provision of stated above, the inquiry authority has the power and jurisdiction to conduct such inquiry to decide the applicability of the act in respect of the establishment. And prior to that, they have said that we have been asked to submit the
So power is there,
power is there.
but whether it is misuse or abuse or proper exercise of power, I think that is the issue
Yes,
here in this petition.
Yes.
Now, that is why I am asking you that what kind of satisfaction is required to initiate such an inquiry?
my lord,
Is there anything?
in the report, their report, which I have shown in the additional, they have himself said that initiation can be done under section 7C. 7B and 7C kindly see. 7A has, earlier 7A has been set aside by this honorable court. Now 7B kindly see. Review of order passed under section 7A. Lordship got it. Any person aggrieved by any order made under section 1 of 7A, but from which no appeal has been prepared under this act, and who from the discovery of new and important matters to evidence which after exercise of due diligence was not within the knowledge or could not be produced by him at the time when the order was made. In earlier order, my lord, that order was an ex parte order. Made on account of some mistake or error apparent on the face of the record or any other sufficient reason desired to obtain a review of such order may apply for review of that order to the office who passed the order. Now, when in earlier round also, we have repeatedly approached for deciding review, they have not decided. Ultimately, this honorable court has interfered with the decision. Now, 7C, determination of escape amount. Where an order determining the amount due from the employer under section 7A or section 7B has been passed, and if the officer who has passed the order has reason to believe that by reason of the omission of failure on the part of the employer to make any document or report available or to disclose fully and truly all material facts necessary for determining the correct amount due from the employer and amount so due from such employer for any period as kept in this notice. Has in consequence of information in this.
No, this 7C has been passed. Where an order of determining the amount due from an employer under section 7A or 7B has been passed.
Or
And if the officer who is now here in the second round, no order under section 7A has been passed. It is initiation, right? By this page 929.
Yes.
Now, question is that I'm asking you once again that what kind of, because they cannot just ipso facto issue a notice everywhere. P.K. Roy issues a notice to himself that come and explain.
that is why, my lord, I have shown in additional affidavit, the
Right.
document I have annexed.
What is the prima facie satisfaction
That
required?
document
Mr.
shows
Roy?
that there is no prima facie satisfaction.
It appears. What is the prima facie satisfaction is required?
My lord, the act is like this. My lord, any.
I have seen the conduct. I have at least have a prima facie view of the conduct.
My lord, may I take your lordship the affidavit in opposition, my lord, when, how it
No,
started?
what is the requirement?
I'm telling your lordship. My lord,
We'll be going into the
it
old
requires,
cases.
to cover an establishment, it requires no order. Because the day an establishment engages 20th number of employee, and the day when the establishment comes within the notifications issued, my lord, by the central government, supposing this establishment building construction, this is, if it is covered under the notification, then it will be covered on the day it engages 20th.
Admittedly, it is a cooperative society.
That I'm coming to the lordship on that. Cooperative society, I'm coming. That also,
Building-
cooperative society is not excluded. Is not excluded.
Not
Lord.
excluded, provided 50 number of.
That's
Now,
right.
the
Now,
earlier proceeding was clearly erroneous. I have seen the documents that
Very-
those where you counted
No, my lord.
50, you counted 50 employees under the contractors.
no, my lord, They are
Absolutely
covered.
clear.
they are covered.
No,
I'll show to you lordship from the documents. From
I'll
the-
show to
from
you
the-
after you show to me.
My lord, all right.
It will be
Let me,
completely, it
no,
appears
no, my lord.
vindictive.
My lord, my lord will kindly have a look at section. Just for your lordship satisfaction. Lordship will come to section 2F. Two F of the definition, employee. The employee means any person who is employed for wages in any kind of work, manual or otherwise, in any connection with the work of the establishment, and who gets his wages directly or indirectly from the employer, and includes any person employed or through contractor or any connection with the establishment. Engages so and so. So contractors are covered. My lord, what the act says, the contractor is to, my lord, collect their part of the, my lord, the salary, then deposit to the employer. And the employer at first will make deposit to the authority. Contractors' employees are covered. Covered. Now, my lord will kindly have a come to our affidavit of
Employee
opposition.
means a person which employed for wages in any kind of work. in furniture,
My lord will kindly,
work of it as stuff is, I mean, goods usually. Who gets his wages directly or indirectly from the employer?
employer. So,
Now, directly is not there.
no, indirectly,
No, what kind of indirect?
my lord, supposing through somebody, my lord, contractor gets the money from the employer and he engages the employees, those are covered. Those are covered under there are decisions, my lord. It's, the dispute is not here. My lord will kindly have a look, kindly come to the page 15 of my affidavit in opposition. I'll begin with that, my lord. My lord, has your lordship got it? No?
Yes. Yes.
My lord, this is the pro forma field by them. They wanted their establishment to be covered. This is on 18/8/1997. My lord has seen that.
On me.
The second, page 16 is the original, my lord, a copy of the original. The power question is, may not have brought for the first time in the High Court, not at any time prior to that. Here in the performance, they have never said that we are not covered because,
It is not for them to say.
no,
You are the person who has to examine,
No.
Mr. Roy.
lordship
Come
is
to
right.
page 17.
So
Come
this,
to page 17.
yes,
There are
17 is-
three contractors,
yes,
File.
contractors,
civil, carpenter.
yes, they are covered,
Yes.
they are covered.
Don't jump to the
No,
end,
no, these
end
are,
of the marathon. We are going through the marathon,
no.
right? Don't jump to the
No, I'm only
Yes.
answering to your
Now-
lordship's query.
4. Wages and salaries paid to the staff 1, 2, 3, 4 up to 11.
Okay,
Right. Now,
these are in addition to the 9.
here we are not running. We are
Then
walking.
will kindly come.
We are walking. Come to page 24.
No, my 21 lordship will read first. What is
Who
their
has
stand?
given some biswas?
My lord,
Who has given some biswas, builder and contractor?
24. Yes, this was the, my lord. It is their documents they have furnished to us. Their documents, my lord.
No, section 13. Come to
Section 13 of the, my lord,
Act.
section 13, I'll come to your lordship a little later. Because the question of section 13
This is a
K,
performer under section 13,
yes,
right? Now, where from you are saying? This performer page 15. Who is the performer in the act?
no, there are performer is annexure 1 to the, my lord, lordship will find in the,
Let us see.
it will definitely, it will be under
Performer. Who is performer? Mr. Ghosh?
देखो तो सेक्शन 13 तक किधर है रेफरेंस 13 तक किधर
Page 15. Now, material information is either para 3 or para 5. Right? Page 15 of your affidavit.
my lord?
Page 15 of your affidavit.
Yes,
The material information are in para 3 and para 5. In the
Yes.
performer. Okay. Exact nature of business, manufacture, process by as the construction of residential plan. And secondly, para 5. They have said they have 9 number of workers and B, workers, employees employed through contractor. Contractor list enclosed record relating to employee engaged by the contractor, not applicable to the society that Biswas and all, they have annexed. Apart from the 9 or 11, whatever they have indicated.
now in the page 15 also this contractor is enclosed.
That is what I am saying.
No.
Para 5 and para 3 information are material for the purpose of this writ petition. Is it not?
My lord,
Para 3 information made in para 3 and para 5, those are material for the purpose of this writ petition, right? They have filled up the performer. They have given the information,
to our inspectors.
all. And it appears from this other documents that some employees are engaged by contractors. Now, for a cooperative society who has given the task of construction to a contractor or a number of contractors, and they have employed maybe 50, more than 50, right? And this society has paid the contractor a consolidated sum as contract against his contractor. Now, then contractor in turn pays it to his whatever mysteries and all, painters, laborers, right? Now, whether this will come within the purview of that employee, those employees will come within the purview of employees under definition 2F. And indirect, basically it is not direct, so indirect. So where you have reached satisfaction, this part is already set aside. This one, the information or the inquiry initiated by you culminating into an order under section 7A has already been set aside by the court. So you have raised the issue that question of applicability of the act is yet to be decided.
This,
Right.
whether, my lord.
If you come to the notice.
My lord, I think I'm not clear
No,
to
no,
know.
no.
My lord,
Page 29.
the finding of the High Court.
Page 29, page
No.
29. No, this
Oh.
is your own version. I am not saying my version.
No,
Come to page 29.
29 of my affidavit, my lord,
No,
No, no.
writ petition,
Okay.
your letter.
Notice.
page 29.
It is your letter. I am not referring to any other foreign thing.
Yes, yes. It says.
But the Honorable High Court has not commented on the applicability of the act.
The language may not be.
No. Has not commented.
Means
This is
government
a-
had not decided. In
So,
fact, it should be.
Now, second para, now to determine the applicability.
Yes,
under the act, a notice is issued, right?
Yes.
Notice is issued to your director to appear. Now, to issue a notice, such kind of notice, what is the requirement? That is what I am asking both the councils,
I'm answering.
whether suddenly one more fine morning, you go to the office, that man goes to the office, issue a notice to him.
We will not.
So what kind of prima facie satisfaction you have reached before issuing this notice? Because this petitioner is a cooperative society. Only in the event 50 plus, you can
We issue,
start
no-
inquiring
we
it.
do not issue notice for that.
That is what I am asking you.
My.
What is the satisfaction you have?
Satisfaction is,
Right.
satisfaction is,
Just
Oh.
because you have a power under the statute,
we will not.
there can be three things. One is misuse, one is abuse, or proper exercise. Now we have to see, for proper exercise, some kind of homework is required on the part of this
No,
man.
Lord.
That is what I am,
Notice is only issued.
because your own inquiry report shows something else. Internal inquiry. So that is why I am asking you.
No, may I answer, my lord?
Ah, yes.
Yes. Notice is under section 7A is issued only when there is a dispute about applicability. Notice is issued for two purposes. One, after the establishment is covered, if any dispute arises as regard the applicability, then that dispute is also decided in 7A, and also 7A proceeding decides what is the amount due. These are the two things which are decided by the under section 7A. In the event of a dispute of applicability, it is a dispute now.
What
And-
dispute?
Whether it is establishment is covered or not, they have raised a dispute. It is a dispute now because the High Court has said that whether it is covered or with the power or not, that was not determined. We earlier did not determine because this question was not raised. In earlier proceedings, we issued notice that did not appear to say that we do not use the power. And my lord, this is a dispute which is decided under the statute by the authority, not by your lordship.
That is what. Come to page 25 again. Please, that is why I am asking. It is, I have not remembered, but yes.
Yes, it's only said when I read para 5.
No, 1 minute.
Only question raised is because it is the
1
use of.
minute, 1 minute. 1 minute. The page 25. The authority empowered to collect the provident fund dues will have to satisfy himself of this requirement while directing the cooperative society to deposit the provident fund dues that it has in its employment, either directly or indirectly, to so and so, workers exceeding so and so, right? So what kind of satisfaction you have?
My lord,
Because earlier inspection report was nothing. Supreme High Court has said.
nothing because there is a
So
reason.
what more information you have
Oh,
got?
more, my lord, it was not gone into because it was never raised. Dispute was never raised. They themselves submitted. They also deposited money.
Now, Mr. Roy, this inspection, only on the basis of this inspection report, you have proceeded again?
My lord, inspection report, yes, inspection
Only
report.
this one?
Yes, because we made an inspection, they submitted a report. After that, they complied to the provisions of the act by depositing money.
No, forcefully, under protest.
Not only protest, by.
Under
by-
protest, and you have
Attach the bank account,
adopted coercive measure to
by
stop
attaching the bank account.
bank guarantee, everything.
This is,
So
this.
they have not submitted to the jurisdiction on their own.
No, they have not said. They have said because your lordship will kindly have a look. The earlier 7A proceedings. Earlier 7A proceedings did not go into the question of
Come to
applicability,
page 26.
26 of the,
Petition.
read petition, my lord.
Yes,
Hmm?
not 26.
Oh, my lord, this is an opinion, legal opinion.
No, I'm not on the opinion.
I have also.
I'm not on the opinion. I know about that.
Oh, they're
I'm not
not,
on the opinion.
Page 28.
Then you can, page 28.
the advice is sought. Only advice is not final. Only
No.
advice is
No,
sought.
Mr. Roy, why you are saying the submission, final submission? Paragraph 2, a recovery of so and so was further recovered as part of file. So recovery was made. It is not that they have come to your office and with all consent has given you. You have the power under the act, you have enforced it and got the bank account seized or something like that and recovered the money. It is not that they have come with protest.
They
And
took-
they did not
my lord,
deposit it.
they took then and there
No,
come.
we want to know the facts first. At least this
No,
court
your
has
lordship
a
is
right,
right. Lordship has.
to know the facts.
Yes, I must tell you, lordship, everything.
Ah.
I must tell you, that I'm.
So after 7A order previously, all the amounts were collected by enforcement of the provisions of the act. They have not come and deposited on their own with full consent and approval. Basically, you have recovered the money
No, my lord,
by coercive measure.
That
That is the one thing. They have not come to, with all consent.
statute provides on us a duty to take that recourse. my lord.
Provides. So ultimately it is found that this 7A is completely illegal. So all these coercive measures are also illegal.
Illegal
Illegal.
for a limited, my lord, limited reason. my
No,
lord.
what more after that inspection report? What more? That was completely dead. That inspection report is dead.
No, after
Now
the,
tell me what more information you have gathered to issue this notice at page 29.
my lord, after that, we issue notice.
29.
We wanted information from them.
They have
Wanted
given
information
already.
from them.
They have given.
No.
That is there.
My lord, my lord will kindly, the last notice also 7A notice, my lord will kindly see. 3-4 chances are given to them. They said you have no jurisdiction.
Yes, they issued a jurisdiction point.
My lord, if we,
Jurisdiction point can be raised.
my lord, only when they provide you the material that you do not use power.
So firstly, what privacy satisfaction you have gathered to issue this notice? Page 29.
My lord, issue notice only because it is a dispute. Dispute must be resolved.
What dispute?
Dispute about applicability there is. They said they do not fall, whether this is not
Now,
applicable.
since it under section 16 of the act clearly says that cooperative society
Without the
Yes.
use of.
will not come under the purview of the act unless
50.
50.
50.
So from which document you have at least gathered some privacy
My lord,
satisfaction that
my lord,
50.
What is wrong with them to submit?
What is wrong with you that why you have not derived the
My lord,
privacy
do you not
satisfaction?
have the
Just
authority
because
to?
everything, every
My
establishment
lord,
you go.
we have
straight
not
to-
decided. We only want to know by issuing a notice. We have not
That
decided.
is what I have seen from your inquiry report. Your
Inquiry,
earlier internal inquiry report, I have
earlier
seen.
inquiry,
I have
lordship,
seen it,
lordship.
how you have proceeded. And because I remember now, this man,
My lord, earlier. inquiry-
if you remember correctly, you might be involved.
I have never involved.
This, no, that man, he has just referred that
Yes,
who
yes.
purchased flat. What is
Yes,
this
yes.
name?
They when.
I remember,
Yes.
I do not know him, my lord.
I remember.
I do not know him, my lord. Lordship may know him, my lord, or that's different, but I do not know him. my lord.
N.K. Dev
No, the other one,
and other one Vikas Roy.
maybe.
Vikas Roy, I do not know. Vikas Roy, I think he retired long back. You know, Vikas Roy is not here.
No, not at that point of time.
Well, not, I do not know any, well, not, so these persons,
7A.
well, not, EPF Act is complete. A code, it's a,
Yes,
it provides the procedure, you can issue someone, your lordship cannot.
but that is not absolute license.
That's right. Well, if you go, if
No
you
absolute license.
if there is a arbitrariness, then lordship will definitely look into it.
What is dispute?
Well, dispute about
Is not
applicable,
defined.
dispute is not defined. Dispute is not defined. Dispute means one person affirms, other denies, it's a dispute.
So what is the condition precedent for issuing a notice? Under
My lord.
7A,
My lord,
you know,
my lord, we,
know the petitioner is a cooperative society.
my
You
lord,
very well know.
no, my lord, I can tell you how we go, how we perform. My lord,
No, you perform is a different thing.
no, so far as notice is concerned, let me tell you, lordship. Because, my lord, ultimately lordship will have to decide, my lord, the lordship will have to given the proper, my lord, the position on facts and law. My lord, normally what happens, establishment covered, establishment we find, our inspector goes. We find that establishment is covered and they do not comply with the provision, we issue them a coverage letter, say your establishment is covered. If they dispute, then a 7-day proceedings initiated.
Okay, now, tell me, before the earlier 7A order, what was the inspection report? Is it available here?
My lord, I think, my lord, these are the basis, the inspection report, I told, but these
This
are the documents submitted before the inspector. 7A, this annexures, the pro forma and all, these
Yes.
they submit before the,
To an inspector appointed under section 13.
they
Then
submit,
what the inspector do?
the inspector collects the material and
Yes.
submit before the authority.
Now,
Submit before
where is
the,
that report?
that, my lord, if he is not next time, not.
Because they are legally, they're appointed and they are legally under obligation to submit a report, right?
Oh, yes, definitely.
Where is that report? On the basis of which the previous 7A order was passed.
Hmm? Hmm?
My lord, how the amount has been recovered, that document I have filed in reply to my to the rejoinder.
The earlier inspection report is available.
No, not report is not there.
Huh?
There was no report, my lord. In their internal inquiry, it reflects that there was no report.
28 years ago, right?
Oh, where is that, that vigilance one?
Yes,
No, no.
Where
vigilance
is that
one
vigilance one?
at page, running page, my lord,
Statement is there. I mean,
starts from page 60.
Okay, here I think.
my lord, report
We'll
says
get
31, I
everything.
think there is in report.
From,
We'll get everything here.
yes, from 60, everything will come up.
Page 31. No, it is after the. Hmm.
Line of investigation.
Hmm?
Investigation report,
Yes,
1997,
yes.
Who is it?
by a squad of enforcement officers. Leroy was there.
No, it's submitted report. The second report after the High Court's order is at page 105.
Let me read this report.
কোনটা 2010 কত নম্বর আছে? তার additional evidence আছে বোধহয়। হুম? এটা তো order. The position. Seven to 97. Yeah. Okay. Yeah.
This report was on what basis?
On the basis of complaint made by us.
Okay.
Additional affidavit.
So it was a complaint when it was made?
It was made.
When is the High Court order?
High Court order, prior to High Court order, it was made. High Court order date is, my lord,
2006.
2006 is the final order. 99 we have approached before this court.
Oh, that was a repetition of 99.
99.
19.
Immediately when the bank account was attacked.
99. I know, there was an interim order perhaps.
Yes,
I have seen in this report. On 10/9/1999,
Yes.
recovery action will be subject to a final order
yes.
and perhaps status quo.
Yes, there is a interim order in that.
So this was in 2002.
2001.
This inquiry report is of which year?
Oh, report
Okay, 2002.
2002.
2002. Okay, 2006. And this was furnished to you.
Through RTI after on 2013.
This man is a member of your society.
Yes.
Dilip Kumar Dev.
He was earlier secretary of the,
Okay.
now the member.
Okay.
At that point of time, he was secretary of
Okay.
the society.
2002, 2006, 2013. So in between 2006 and 2013, what further material, Mr. Roy? In between 2006 High Court judgment and 2013, that notice. What further material could be gathered by the organization? Any idea?
I think the
One more, I have seen, I have found. One more. Page 102. Page 102,
is the
running page.
It is in their affidavit in opposition.
Your affidavit in opposition.
No, it is a
That
affidavit,
is a document of 2013.
affidavit in opposition filed by the respondent.
my affidavit in opposition.
Yes, yes, yes. That is the only document in between High Court order and the notice.
No, it is 1998,
No.
102.
Page running page 31,
Running pace,
31. Running page of that affidavit,
yes,
31.
31.
This is the only document in between High Court order and notice.
This is the inquiry report.
Huh.
Inquiry
Now,
report,
the inquiry report by 3 enforcement officers,
yes.
right? Now here, standing counsel said so and so, puts an end, 1 minute, 1 minute. Thereafter, if the number of employees are found to be more than 50 and the society is found to work with the aid of power, in that case, the establishment would come under the coverage. This is the view of the enforcement officer who submitted inspection report to the Assistant Provident Fund of Commission, right? It was in 27th May 2013.
And based on this,
So based on why, then they have said nothing. They have said nothing. Only if the petitioner society engages 50 and aid of power, then the establishment would come. So why?
I have also annexed this document in writ petition,
no, my lord.
page 35.
When we asked them whether your establishment is, I mean, working with the aid of power, and they said, we will not give it to you.
Page 30, they have taken the
35.
reply to your letter.
Thirty-five is the 7A order. my lord. My affidavit in opposition.
Paragraph 3 of the repetition, paragraph page 30. They've said our society does not have any employee or worker at all, not to speak of 50 workers, and so employed to work with the aid of power as provided under section 16(1)(a). Your notice and the reference has miserably failed to point out as to whether any such preliminary inquiry was at all made by you to arrive at such objective satisfaction. They have done so.
7A doesn't, my lord, say that they have a right to ask the 7A, my lord. 7A is the proceedings, my lord.
Right.
7A is the proceedings.
Right.
So we have prima facie material to show they are covered, and therefore it is not a final. If we have material that they are using power, then that's the end of the matter.
Till May 2013, right? Your inspectors do not find anything after causing inspection to the petitioner's establishment. And 3 inspectors, enforcement officers have filed a report on 25th May 2013. That is after the notice. Notice
lord.
under section 7A. This notice was issued on, I think, 11/4, right?
Which
Your enforcement officers
Oh,
in May 2013 said, we don't know. Right? They have submitted a report, reply that we don't have any employee, no aid of power.
And they are
So what objective satisfaction?
they are
will there?
asking the documents of 1996, 1998. We said that under the Cooperative Societies Act, section 80, 10 years old document, we cannot keep preserved.
Section 80.
80 of the cooperative societies, Assam
2002 or
Cooperative Societies,
1949,
2007 Act also there.
page, section,
It is earlier Act,
section.
section 80 of the present one. Account, record and document to be maintained. Every cooperative society shall keep at its head office the following account, record and documents, namely copy of this act of amendment so and so, by law, so and so. The books of accounts and records shall be open to inspect by,
Which provision?
no, it is earlier, my lord, four.
Subsection 4.
Yes, the books of accounts relating to period at least 10 years before the current financial year,
Hmm.
together with supporting record and voucher, shall be preserved unless otherwise required for a longer period.
Now whereby they have asked which document? Which one is the letter? They have
Unless
asked for
otherwise
10
written.
years. By which letter? Stated.
My lord, kindly see page 35. My
One.
writ petition, in compliance with your letter so and so, undersigned, you have visited the aforesaid for inspection and meet Dilip Kumar Dev, secretary, and other member of the
Oh.
secretary was requested to produce the following record before squad: salary, wages, register of all employee from the date of setup. Lordship got it.
Page 40,
Page 35 of my writ petition.
35,
They have also annexed this document.
35. Yes.
The secretary was requested. Lordship got it. To produce the following record before the squad for inspection: salary, wages, register of all the employee from the date of setup.
Hmm.
Books of accounts from the date of setup. Mr. Dev could not produce the aforesaid record from the date of setup, showing the provision that they are legally liable to keep the record for 10 years as laid down in section 80 of the Assam Cooperative Societies Act.
Hmm.
The secretary, however, produced the following record before the squad for the inspection.
Yes,
Received-
documents are produced,
Produced.
profit and loss account,
Yes,
profit and loss account. Okay,
list of present member of the society, copies of AGM. meeting.
your enforcement officer says so.
Yes,
Okay. So scrutiny.
Cover-
Time of resource. Other things are already discussed. Okay. Then this man is issuing notice after notice.
yes.
All relevant records. One more opportunity. Okay.
And further inform Dev secretary requested to extend time.
That is not,
Appearing in the
One
inquiry,
more opportunity, relevant records.
that is for appearance.
they themselves wanted time below.
But
So they may have,
text and tenor of the language used by this authority
that,
appears to be,
no, my lord, that of course, they are not expert, they
whether
are not,
in good taste or bad taste.
I'll have to say-
Will be looked into,
I'll have to admit, my lord, they're not in proper form.
because the text and tenor of the language used in all his communications. What is the name of this man?
As thus.
Hmm?
The order passed by as thus.
As does. He was part of the earlier program. Yes, what more stand you have taken in the affidavit in opposition?
Basically, my lord, we have said that since it is,
No, after the notice, Mr. Roy, I'm asking you. Because I have to look about the provisions of the act, both the act. This notice was issued on 11/4, right, page 29
of the writ petition, my lord,
of the writ petition.
29.
And this page 35. Report, this is inspection report. Inspection report,
Yes, yes.
right? This was submitted by 3 enforcement officers on 27th May 2013.
No, my
And
lord.
basically it is to that authority,
Yes, my lord.
right? And I think it is in compliance with your letter dated so and so.
Yes.
16/5.
2000.
They have visited, right? The establishment on 22/5/2013 for inspection. Right. So this is after initiation of inquiry under section 7A.
They can, because the authority can say, make a further inquiry.
Can, definitely can. No doubt about it. So non-cooperation, suppose we assume non-cooperation from their part because of your language used in the letter. Enforcement officers, they have visited, they have met, they have interacted with the persons in charge of the society and submitted a report on 27/5/2013. Right? So thereafter also you are issuing notice.
To grant them opportunity to.
Grant
but
them
this
opportunity, but assuming
Proceeding continues.
assuming that person say their non-appearance is non-cooperation,
Okay.
non-cooperation,
Further opportunity during proceedings.
non-cooperation, then you have a power under subsection 3A of section 7A.
Yeah.
Right? To
Section
decide
3,
the
I got it.
applicability of the act. On the basis of the evidence adduced during such inquiry and other documents available on record. So enforcement officers
So we,
report is there, that is a document. Then you
Because-
can pass an order.
we can. We can,
Huh.
but we have
Then
not. We have not.
Was there a stay?
No, we have not. We have not. We wanted to give
No, it is
opportunity there.
cooperation, was there any stay here? Okay, stay.
No,
With
but Lord,
regard to the so and so. Something is stayed,
that does
Don't
not
know.
vitiate, my lord, because
we don't know.
we are timing and again granting them time to, in order to enable us to satisfy.
No, they have made person clear. And the earlier inquiry vigilance report. Says so. Anything, Mr. Anything important to be shown here
From,
from the case record,
from the,
from your side? Any other documents?
no, documents are, my lord, these are the only documents
So,
I can.
law point,
Law point is, my lord, that the authority, the High Court, Honorable High Court order, the earlier order, did not say that the establishment is not covered. It only said the authority did not take into consideration whether the establishment is working with or without the aid of power. It did not quash as such the determination. But the order is quashed, and then we still have the authority, the opportunity under the act to determine whether the establishment covered or not. In order to ascertain that, we have given them adequate opportunity. They have not even the inquiry stage, it's premature inquiry stage, they have come. If they are not satisfied, then they can go file a review under 7B and file an appeal after the order. Final order, they can file an appeal. But they have not done that. They simply said, we will not cooperate with you.
No, they have said, come to.
And
no,
they,
what is
and
your-
time and again, they wanted time also in money.
No, phase 30, phase 30. They have clearly said, you withdraw. That is what phase 30 says. After receipt of notice, you withdraw this one,
Which one, my lord?
plain and simple. Phase 30, we
Yes.
don't have 50, we don't use aid of power. So there is no objective satisfaction. You have miserably failed to point out as to whether any such preliminary inquiry was there. Thereafter, inquiry was made by you. 3 enforcement officer discarded your thing, then phase 30, they said, you drop this one.
Then 33 also.
Drop this one, plain and simple.
No, 33 also there.
Huh?
33 after enforcement officers square,
Yes,
another,
then plain and simple.
yes.
My lord, they are.
Withdraw. Notice, their stand is very clear.
Okay, my lord, they are, my lord,
This
saying,
opportunity, granting of opportunity is an excuse.
so because under 7A, we'll have to grant them an opportunity. That's why we have not passed
That's
any.
it. No, once they said on 2 occasions, you withdraw. This is not maintainable. That's all.
But finally, they appeared and they said, they appeared before the other, saying the same thing. So we said, we are granting you opportunity.
What?
Yes. Granting you opportunity.
Which document?
So my lord,
says?
this, if they say,
Which document?
my lord, they are saying,
Which one?
my lord, finally,
Finally. Page 31 says this is complete harassment. Which one?
no, why I am saying, my lord, my submission. is-
Which one?
We appeared also and said that you have no jurisdiction to decide the jurisdiction point. Then also they have not done this.
No, my lord. Then, since there is no order passed. Since there is no order passed. And your lordship is indicating that the authority had the opportunity to pass an order. They have not passed. Lordship will direct them to pass an order this way, either way. For non-appearance, my lord, their non-appearance doesn't mean that their establishment is not covered. Just by saying it's not, they'll have to produce documents.
No, what privacy satisfaction you have derived? That is why what I am asking you, your 3 enforcement officers have submitted a report.
My lord, since from 97, we have the documents to show they're engaged. More than
97 is
20.
gone, Mr. Roy.
But they,
That report I have seen. We have seen, I think, that report,
Yes.
97 report, 97
97,
report we have just seen.
I don't think 97 findings are
We have
gone.
just seen, Mr. Roy. We have just seen, I think.
In,
Where was that? Where it was annexed?
in the addition, that inspection. Or they have annexed,
They
They
have
have
annexed somewhere.
in the affidavit in opposition. Page, running page maybe 90 or,
Somewhere we have seen just now.
yes. Affidavit in opposition, page 15, running
Page?
15. It may be
15.
89 running page.
15.
On 15.
Running page
We have
89.
seen somewhere.
Well, the statement submitted by
Oh,
them.
no, in the vigilance.
In the,
Vigilance.
yes, in the
It was
vigilance,
mentioned.
it was
It was
mentioned,
mentioned.
mentioned in vigilance.
The statement submitted by them cannot go.
And they have not
What?
replied to the vigilance report.
We have the documents in it. This cannot go simply. This is
Yes,
not what.
yes.
This is
Cannot,
not what.
cannot go, cannot go.
Cannot go.
Yes, 48.
Page 48. Oh, yeah. Okay.
See that after bold paragraph, then and whereas due to non-cooperation, the representatives of the establishment, the inquiry authority could not proceed any further as both decided to leave the proceeding midway. While leaving, Mr. Ghosh asked for the full name of the inquiry authority, stating that he wanted to file a contempt against him.
My lord is finding the, my lord, see,
Then
It
he quoted 7A. Right. Then all the provisions. Then whereas page 49 has the power to conduct the inquiry and jurisdiction.
my lord,
Due
the
to abrupt departure.
establishment put a threat to initiate a contempt before the authority. my lord.
Abrupt
With the
departure,
judicial authority.
abrupt departure of the representative. No, your previous contact shows everything. Vigilance report, your own document shows everything.
My lord, that,
The inquiry for the day could not be concluded. However, taking into consideration fairness, he speaks about fairness. The establishment is afforded one more opportunity to appear with all the records so and so before the undersigned to submit any further information. So
I do not
this
comment.
is the materials before the authority. So these are the materials, nothing more.
For having material more than that, we have given an opportunity, they are not cooperating, that's all.
No, what is the condition precedent for 7 years? That is what I am asking.
7, as I said.
There
my
are
lord,
two, yes, there is a dispute. He has to form an opinion because after the enforcement officer's report, right? They have said no 50, no aid of power, earlier order, High Court, they are saying, so you withdraw. That is their case. Then after issuance of notice, you appointed 3 enforcement officers, right? They have gone there.
Make further inquiry.
Right, they have gone there. They have interacted with the person in charge of the society. You cannot say that they are not cooperating. Then he said, with this much of document, profit and loss document, for 10 years, he has submitted to the enforcement officers. You cannot say that he said, this much is available, please take this record for 10 years.
My lord,
Right. Well, let me find out the facts. These enforcement officers submitted an inspection report on 28/5/2023. Right. They said unless something is available that this society employs 50, then only this organization would come within the purview of the act, right? They have submitted a report on 28/5, right? Then what prompted this authority to issue another notice under section 7A?
now may I submit? my lord?
Yes, please.
May I submit?
Please.
Now, my lord, the inspection made by the inspecting authority in a 7A proceedings are not subordinate to the authority. They are a party before them, like the establishment. As the authority is a judicial proceedings, my lord, is a judicial authority. The authority may not be satisfied with the inspection report.
Hmm.
Like we are appearing before Lordship. Lordship may not be satisfied with my report, my submission. Lordship may ask the other side to come up with your case. It's like that only.
Okay.
He is an authority, my lord. He is a judicial authority under 7A. He has the power to ask for some
No,
reports.
quasi.
He can summon quasi judicial authority.
Not judicial.
No, not the, it's a quasi judicial authority. I'm sorry.
No, he exercises the power of,
Yes.
so
So
his
it is not
proceeding is quasi
necessary.
judicial.
No, yes.
His proceeding
Quasi,
is
quasi,
quasi.
like he has the.
Now that man has filed the affidavit in opposition. What are the important points here? That man himself has filed a affidavit in opposition. Now, I could find out. He is the man. Oh,
It is not necessary for the authority to just accept a report, my lord, and
now what he has said,
he has considered this and asked the other side. They are not cooperating. So lordship will ask them to go ahead, authority, go ahead. Either way.
no,
pass the
after
order.
11 years, it is not gone ahead. You are not interested that you have not sought vacation of the order also, interim order. After keeping this petition pending, it is not as an extreme.
I
situation.
have a fellow soldier, okay?
And what about repetition was allowed? Meaning thereby the amount was to be refunded. That was the purpose they have made the application. Did you make any refund?
No, my lord, I don't think, I don't have any record,
No, they have
instruction on
not
that.
refunded amount. That is the main
No, I could-
initiation of this proceeding.
Nothing should be said.
I don't.
Court
have-
has that limited understanding, which can
No,
be
if-
inferred.
If your lordship ultimately decides against us, we'll have to, you know. We'll have to make refund,
No. But
because this
repetition
was deliberated upon, whether you to refund or not. Thereafter only, they wanted, you know, but an opinion, I mean, the suggestion from the higher authority. But that thereafter, 70%.
will not say much about the text and language those authorities have used. Mr. Roy, don't defend those order.
No, I'm not.
Don't defend those
I'll
language.
never.
Don't defend those language. That court will be,
At the very beginning.
court
said-
will be constrained to make observation about that.
No, yes, my lord,
This, your that feeble spacious plea of not refunding money. I am not going into that aspect.
no, refund.
This kind of excuses the authorities have made is atrocious.
The language is really, my lord, that
Yes, don't go into that aspect.
No, I'm not going.
If you make any submission, court is going to make very severe. objection.
I will never go. I'll never go, my lord.
This
I'm
is
an officer.
very bad taste.
My lord, I'm an officer of the court, my lord. I
That is
cannot
in very
indulge
bad
on.
taste.
That is better. At the beginning, I said, my lord. At the beginning, I said.
Beneficial legislation, that does not mean that you will enforce it in any manner whatsoever.
No, my lord, my submissions, I'll end up, my lord. I'll not.
1 minute. So I need to know the provisions of the
That's-
act. That is why I am taking time also.
My lord, I'll bring to your lordship 2 more provisions, my lord. I think your lordship may need to go. Personally, well, I would have been happy, but very happy. I would be very happy because it's my land fence society.
No, we are not in that. We are simply the
Because,
facts of the case.
yes.
Only what has transpired.
Because I'm bound because I have to defend my client, that's.
Right. No, paragraph 4. Mr. Bose, you did not ask for refund?
Yes.
You have asked
that
for refund,
I have shown,
but he has denied it.
no, kindly see,
He has denied in paragraph 5 last time.
he has denied, but I have annexed the document also. My lord, kindly see page 28, their document. It shows we have applied for refund.
Yes, Mr. Roy,
Lordship,
come to paragraph 9. Let
Oh.
us read together.
our affidavit, my lord.
Yes, yes.
9 of the writ petition report denies disputes and so the report submitted by the SWOT inspector stated so and so did not concentrate on the aspect of applicability of the act. If it failed to indicate anything anywhere, if the establishment worked with or without the aid of power, right? The inspection report was incomplete, non-conclusive, non-comprehensive, rather contradictory by drawing any conclusion on the inquiry. As such, it could not be relied upon. That is what I'm saying, upon the decide the applicability of the establishment. As such, another order was passed constituting a fresh squad of inspectors of 2 submit a conclusive report in the issue of question. Meanwhile, since the matter could not be decided merely relying on the report of inspectors as per law, it was necessary to hear the representative of the establishment, and as such, case was adjourned next date. Wide notice dated. Meanwhile, fresh squad is constituted.
Okay, what did your fresh squad submitted? Your fresh squad. So you
I think
go on appointing squad. So what did your fresh squad submitted?
I think before the
Place it before the court.
if there is any.
Because you are appointing squad after squad, 2 squad,
That's right.
right? Because we could decipher the intention. So fresh squad is fresh squad. He is
Well,
not
that's why that
happy with
That's why.
three enforcement officers report. He himself says,
Yeah,
non-comprehensive, non-conclusive,
Yes.
incomplete, contradictory. Now he has appointed a fresh squad. So what did this fresh squad? Maybe he's blue-eyed boy. So submit the fresh report.
Or
That will,
Well, I
I think,
think- and
if that fresh squad also submitted a report,
whether they have submitted report or not, I do not know. Well, I'll have to check up, but then.
Mr. Chakraborty, any idea?
No, they have not gone.
Huh?
No.
Well, before that, I will
Immediately we
immediately.
got closed before this.
I think after that. After that, it is ordered fifth. After that only they have approved, my lord.
Okay, what more provisions? you
After
got?
that they have approved. That's why.
Okay, what more provisions
Huh?
to show?
No, your lordship was saying
Hmm.
that the contractors are not covered. My lord. The scheme, your lordship, see the scheme. EPF scheme, the contractors are required to. EPF scheme 36B,
36B.
B of the EPF. 36B, capital B of the EPF scheme.
EPF scheme.
Hmm.
Hmm.
The contractors has a duty,
Hmm.
Mueller got it.
Hmm.
Every contractor shall within 7 days of the close of every month submit to the principal employer, that is the establishment, principal employer, a statement showing the recoveries of contribution in respect of the employees employed by or through him, and shall also furnish him such information as the principal employer is required to furnish under the provisions. Now, when you kindly see, come to page 30, para 30. Paragraph 30,
Para,
30 of the
section,
scheme.
rule,
It is para.
para.
13 of the scheme.
Huh?
Payment of contribution, lordship got it.
Hmm.
The employer shall, in the first instance, pay both contribution payable by himself in the scheme referred to employers, and also on behalf of the member employed by him directly or through contractor, the contribution. So employer is to deposit first
Hey, I paid for you. Yes.
both the contribution and then recover it from the. Then subclause B2 says, employees also through contractor, then they will make recovery from the contractors. And section 2F, as I've earlier shown to your lordship, that employee includes the contractors employees.
2F.
2F, small f. So, my lord, the authority, your lordship is right. The inspection report did not come to any finding in the inspection team, whether it is using power or not. The 7-day proceedings proceeded. The officer conducting 7-day proceedings was not satisfied with the inspection report. They wanted to grant further opportunity to the employer, the establishment, and also simultaneously
Yes.
directed fresh inspection report in order to come to any finding. So authority could not come to a finding after that because of the read petition filed and there being an interim order in their favor. And since it is a proceeding under section 7 capital A, which provides the detailed procedure below, as to how determination is to be made, how the material is to be submitted before the authority,
Hmm.
which mechanism may not be available here. That has to be determined by the statutory authority because and my lord, I have just I'll place before lordship one decision of the Supreme Court. Lord.
Yes.
Original idea, I put in the ask. I'll not bother your lordship with other decisions because lordship has
Now tell me what is the relevant one?
this 2010 4 SSC 772.
2000.
10 4 SSC 772. With regard to interference by lordship in this Article 26. Para 31 to 36 minutes. Though it is not under the EPFO Act, but statutory. After the position, 7 proceedings. Chamba. Yes, sir. Oh,
This is not specifically to this act.
Yes, to act, but then the law
This
is
is
like,
para, FEMA.
yes.
Do you have any specific decision?
Oh, my lord.
Find out some specific.
It's a little
I
open,
want to
open.
draw analogy
Yes,
equation.
but then
There is so many litigations under this act.
so many.
So many.
I didn't know, my lord. I need
Yes,
to-
so I don't
because the
think
lordship
this-
is so.
this is
lordship
going in a
dealing with-
different-
Even the other day, I argued here before lordship a case, lord. The lordship, though judgment is not yet to come out.
Yes, because some.
I think lordship, I'll place your lordship tomorrow, my lord. Tomorrow all judgments.
We'll put in.
Tomorrow I'll give you lordship. Lord.
No, we'll try to put it on a date
That is better. I'll give it tomorrow.
because some more legal issues I want. Maybe I
All
may
right,
query.
that's correct.
Right? On legal issues. Factually, I have.
That's it. My lord,
Anything factually?
Uh,
Factually, it is done.
on legal issues, lordship is.
Only legal aspects if some
And-
queries are required.
I assure lordship, I'll not take, my lord, more than 10 or 15, 10 minutes. of-
Because facts are
Clear, my lord, clear.
now
I cannot,
clear
we cannot go back from the fact. my lord.
My lord, the document
and litigation is continuing since
No, lord.
1996.
regarding inspection document, we have also submitted in affidavit in reply
What?
before this court, regarding which we have submitted before the.
My lord,
EPFO.
these are new facts.
That document we have also brought here.
I could not have an opportunity.
No,
The
no,
three enforcement officers have said the
Yes.
profit and loss statement for 10 years.
that.
They have been,
Yes,
those are submitted before them.
yes,
by
that
the
document
secretary.
also I have
So that is there.
submitted before
And
this.
they have said that we don't have any document.
Yes,
So what more? They cannot create
We cannot create a
They-
document.
They said they didn't have any document at all. They said we don't keep the documents.
Yes,
It's not required to keep the document statutorily. 80 I have seen. Section 80 I have seen.
Okay,
subsection.
my lord, then also that,
Why? When
lord,
statutorily not
the-
required.
unless otherwise required, the lordship will see the statute, unless otherwise required.
No,
That means this person
Oh,
is continuing.
that thing, Mr. Roy, if something is required to be preserved for a particular 10 years period.
Because of the pending.
Suppose on the 9th year, somebody comes and says, this will be required, keep preserved. Then only it can be preserved beyond 10 years.
Okay, well,
I had the opportunity to also to do preservation for 5 years. Then some document was preserved on the basis of instruction received from the CBI beyond 15 years. Those are there, but unless you do not receive any instruction, statutorily you are required to preserve it for 10 years. 10th year plus 1 day, you destroy. And they can take the plea also.
more because they are society lordship house. I understand their difficulties, my lord. I understand because their housing society consists of many inmates of the house. So who will keep, my lord? That's true.
No, exactly on the point, I remember reading a judgment. Exactly on the point, how this kind of, because this society is basically a society of house owners, flat owners,
flat owner.
is it not?
Yes,
They
It-
registered
it is a
one
society of flat owners.
and why they will register it?
no, no,
Because
No.
before registration,
Basically, it is a society of flat owners or not?
flat owners,
I
Flat
don't,
owners?
91 flat
No,
owners.
no, your own officers, they have book flat, so don't try to divert the issue. Society of flat owners, right? And they may have undertaken some construction of the buildings for their respective flats. And they have engaged contractors for construction. I think that is the issue.
Even
And these contractors engage mistries, painters, laborers and all. So it is a cooperative society. So question is 50 plus 8 of power. That is the issue.
only issue is 8 of power, my lord.
No, plus 2 in
plus
50.
2,
Both.
50 and yes, no, here the issue is 50 is determined, my lord. 50 is record on record.
That is what that I remember reading that Supreme Court decision exactly like this petitioner society and where the Supreme Court has interpreted. How the Supreme Court has interpreted, that is why I want to find out that I need some
But-
today's night. To sound this. But Roy, only on a legal issue, goes
Yes,
yes, yes. I'll
Only-
find out.
whether they are employees. And 7A, Mr. Roy has already submitted that that authority has full liberty to proceed with 7A. Your contention is that some privacy satisfaction is required before proceeding under section 7A.
7.
So on that point, just only that limited issue. Because it may have some consequences in other cases.
that's right, that's right. That's right.
Had it been an individual
Well,
case,
lordship, lord, I would have considered, my lord, because as I said, my lord,
we are not restrict this, we have some holidays, 7 and 7.
My lord, may not be 7.
Why?
6 and 7 I'll be out.
7,
7, you are out.
Yeah.
7.
We'll try to keep it on 31st.
August. NCLT. No, 31st.
Difficulty.
Ninth is, you know, 7, 8.
On first then, at about 3:30 you will hear it. At about 3:30 you will hear it. That is the understanding. Only on the law point,
Yes.
3:30. That will do.
Yes.
Heard Mr. S.K. Ghosh for the petitioner, Mr. P.K. Roy, senior counsel, assisted by Mr. H. Chakraborty, learned counsel for the respondent number
All
2 to 3, 2 to
5.
5.
2
Any
to 5.
Mr. K. Gugoi, Central Government Council for respondent number 1. He is Union of India.
Yes.
Yes, Mr. Gugoi, you want to say anything? Release the case again on 1 night. Mr. Roy, that day we drafted the other part we dictated
Okay.
in these old cases.
Yes, yes.
Can you go through it? We have typed out the facts.
No, Lord.
Mr. Das,
Hmm?
we may have running short of time.
Oh, well, what matter is called.
Okay, Mr. Chakraborty can check. Mr. Das,
Yes.
you were there. Mr. Das and Mr. Chakraborty. You go and Mr. Gugoi, you go through it and return the draft to me.
Yes.
Can it be done? একটা draft এটা আছে। But a copy was handed over to you, no?
No, earlier.
Oh, I asked at 2 o'clock
Yes.
to hand it over to you so that you can go through it. Have you got anything for submission? Mr. Das, can you prepare a short submission written in those old cases?
I can.
I have
What?
given you, Lordship. I have been on the very first day.
Submit,
Yes.
let us.
I have given a written submission.
If I did a sound, written submission of submission.
Along with the list of dates will have given.
No. Pause this for a minute. Apart.
Not too much.
What about 4? Anybody 4? Item number 4?
I am appealing on behalf of BD Goswami. Matter is got instructions, sir.
No, you should have told me at 10:30. Why you are waiting till 4?
Code number 3, Lordship.
Mr.
JM Google.
J.
JM Google, Lordship. I am appealing on behalf
Learned Counsel appearing for Mr. B.D.
of BD
Goswami.
Goswami.
Learned Counsel for the petitioner has submitted that the subject matter of the petition has become infructuous. Mr.
Bidas, my lord.
B. Das, Learned Counsel for
All the respondents.
all the respondents is present and has submitted in similar line. Full stop. There, item number 4. In view of the above submission made by the learned counsel for the parties, the petition is dismissed as infructuous. Okay. Written submission.
Item number 6 to 10.
This one.
Yes, I think it's this. The citations also few, I may add some, I have given.
At the end.
Yes. I think it should be there. Huh?
This one is belongs to us.
Anyway.
This one 1925 is our case, in our case. Synopsis, short.
Oh, 1925 is by Das.
Yes.
No,
Okay.
it's not me.
Okay.
I have another one.
You have another one.
Hmm.
एक full option, the last full option. No, file got a synopsis of issue. এটা পাইছো এটা পোৱা নাই এটা synopsis পাইছো What আছে উপর এনেকুৱা Oh. One more copy of the, one more copy is there. Mr. Chakraborty, one more copy, go through it. Nine.
Have your lordship got my written?
In submission in WBC 1925/2009 is.
My lord, I have given in 2872 of 2013.
2013 or different petition of the water. It is available.
Sure.
It is available. এইকেইটা ওলাই আনিছো। পিছত দি আছো। Let this be on 610, 6, 7. My lord, this case is 7. You may go through it. 7 these cases,
On
7th September,
September.
or before it possible, not possible, not possible.
7 September.
So thus you go through it.
Yes, ma'am.
In the meantime, I'll dictate this part, your submissions. Mr. Roy, I'm dictating from your written submission.
Lordship.
Mr. Roy, learned senior counsel, appearing for the petitioners in item number
Except item number 6.
7, 8, 9, 10, right? Has submitted that by the impugn order dated dated 6/3/2010, passed by the Deputy Commissioner cum Collector, Roman N. Collector, comma, Kamrup Metro, comma, impugned in the writ petition WPC number 2872/2013, comma, the order of derequisition passed earlier by the additional Deputy Commissioner, comma, Kamrup Metro, was cancelled after more than 5 years for reasons that, since under circular number dated 15/7/1993, comma, the Deputy Commissioners were declared as collectors within their respective jurisdiction under the Land Acquisition Act within bracket since repeal, and the Assam Land within bracket Requisition and Acquisition Act 1965. The order of requisition passed by the additional Deputy Commissioner Kamrup Metro on, Deputy Commissioner Additional Commissioner on 30/11/2005 is not tenable in law. Sorry. I think Deputy Commissioner. Mr. Sogodi, page 6 of your written arguments. Once something goes inside as typographical error, it is very difficult to correct.
ADC. Oh, additional deputy commissioner, it should be deputy commissioner.
Deputy Commissioner on, I think,
30/11/2005.
30/11, 6/3/2010 perhaps.
Hmm?
Is not tenable in law. Stop.
6/3.
By the Mr. Chakraborty, please.
6/3.
Please take care. By the impugn order dated 6/3/2010, comma, it was further provided that the petitioner's parcel of land measuring 7B0K14L, comma, covered by tag number 146 and NK patta number 14 would stand continue to be under requisition for the purpose of construction of Adabari bus stand of the GMC WEF 22/10/1986. By the subsequent notification dated 6/8/2011, issued by the Deputy Secretary to the Government of Assam, Revenue and Disaster Management within bracket LR Department, dated 4/12/2011. A notification under which was a notification under section 4 of the LA Act 1894, it was notified that the said parcel of land of the petitioners was likely to be needed for a public purpose, PIJ, Adabari bus stand within bracket park. Full stop. The public purpose was therefore, shown to have changed from bus stand to park after about 25 years. Full stop. The deputy commissioner, next para. The deputy commissioner Kamrup Metro earlier passed an order on 1/11/2007, subject matter of challenge in WBC number 6512/2007, whereby while rejecting the petition filed by the petitioners on 29/10/2007 for restitution of possession, had also given the same reason that it was the deputy commissioners of the district who were empowered to exercise the function of collectors within their respective districts under the say 2X, that is the LA and Assam Requisition and Acquisition Act 1964. Apart from the said plea, an additional plea of rejection was taken therein that the commissioner GMC had intimated that he had never signed a letter dated 29/3/2004 to the deputy commissioner, and no letter from the Patadars requesting de-requisition was processed in file, and the request was not made to the deputy commissioner. It was further provided in the order dated 1/11/2007 that since possession of the land was taken over, soon after the land was requisitioned, and at no stage, it was given back to the Patadars, the question of disposition and restitution of Patadars in DAG number 146 did not arise. But the reason shown for cancellation of the order of de-requisition, that after requisition of the land, at no stage it was given back to the Patadars, the question of disposition and restitution of Patadars did not arise, is expressly illegal, since the authority, while passing the said order, failed to understand the distinction between requisition and acquisition and the true purport thereof, inasmuch as release from requisition is independent of delivery of possession. Full stop. It is straight law that the original order of requisition, if the original order of requisition gets vacated, the moment the order of de-requisition is passed under section 8 of the Assam Land within bracket Requisition and Acquisition Act 1964. This sentence appears to be incomplete. Page 8 of the written submission.
My lord,
law says that the original order of requisition gets vacated.
Well, this
moment the order-
Indromon case has clarified that.
Huh?
This case, 1989 2 JLR has clarified. that.
Sorry. He has submitted that. It will outline package. The moment the order of de-requisition is passed under section 8 of the Land Requisition and Acquisition Act 1964, comma, the original order of requisition gets vacated. He has referred to the, in support of his submission, he has referred to the decision in Indra Mohan Chakraborty and others versus State of Assam and others, comma, reported in 1989 2 JLR 281. Post. It is his submission that though the Deputy Commissioner Kamrup Metro, by the order dated 1/11/2007, in the order, had mentioned that the Commissioner GMC had informed that he made no request to the Deputy Commissioner to de-requisition the land, and that no such letter was written by him on 29/3/2004. But Deputy Commissioner Kamrup Metro, or for that matter, comma, the Commissioner GMC, in has not denied or disputed about the endorsement made by the Deputy Commissioner Kamrup Metro on the letter of the Commissioner GMC dated 29/3/2004. Which endorsement reads as quote unquote D full stop R full stop Rajbangshi, comma, SDO within bracket S full stop PL exam full stop, and take necessary action as desired by GMC as the DC dated 19/8/2004, unquote. While passing the subsequent order dated 6/3/2010, comma, the Deputy Commissioner cum Collector Kamrup Metro, while cancelling the de-requisition order dated 29/03/2004, comma, did not take the plea that the Commissioner GMC had not made any request to him for de-requisitioning, but only said therein that the additional Deputy Commissioner had no power to pass the order on de-requisition, comma, in view of the government circular dated 15/7/1993. He has thus contended that Mr. Roy has thus contended that the plea of the respondents are therefore quite inconsistent. In the affidavit filed, in the affidavit in opposition filed in the writ petition, comma, WBC number 2300/2010, no specific averment has been made except in reply to paragraph 9, except stating that the same are matters of record. Thus, it can be stated that the respondent authorities had admitted the fact of request made by the Commissioner, GMC on 29/3/2004 and the endorsement of the Deputy Commissioner Kamrup Metro thereon on 19/8/2004. It is contended that the plea that additional deputy commissioner was not authorized to issue the order of requisition dated 30/11/2005 is not tenable in the face of the order passed by the deputy commissioner Kamrup Metro on 1/11/2007. In view of the provisions contained in 19(1) of the General Clauses Act 1887. According to section 19(1) of the General Clauses Act 1887, a law relating to chief or superior of an office, shall apply to the deputies or subordinates, lawfully performing duties of that office in place of their superior to prescribe the duty of the superior. That apart, the additional deputy commissioners of the state of Assam are always performing the duties and functions of the deputy commissioners in each revenue district in terms of the provisions of section 2(m) of the Assam Land and Revenue Regulation 1886. He has drawn attention to the order of requisition dated 22/10/1986 as the said order was passed also by the additional deputy commissioner Kamrup Metro while performing the functions of a collector. Full stop. Therefore, it cannot be said that the order of requisition dated 30/11/2005 has suffered from any illegality. What is your line of submission, Mr. Roy? Basically, you are basically harping on that Chakraborty or something additional deputy commissioner's letter.
It
The
says-
requisition.
Yes.
For what purpose?
My lord, that says section 8, says the provisions. They said that the land was not handed over, possession was already there. There is no question of possession. The only possession is deemed to be with us under the provision of that. This is what Indramohan Chakraborty has said. Because requisition, we do not sell it. Ownership is with us. Yes. And the Indramohan Chakraborty says, when the derequisition order is passed, the moment derequisition order is passed, the possession automatically deemed to be with the original owner. It requires no handing
Fact
over.
of the matter is that you have been forcefully evicted.
Thereafter, after the derequisition
So,
order,
ultimately, so what is the point you want to bring home?
no, I'm challenging that assertion, that plea taken by the authority. That this land was not handed over to you, so derequisition is inconsequential. Because you said the derequisition and you were forcibly.
When this 59 bighas was requisitioned in 1986, possession was taken over.
Possession was taken over, but say even except that 146, Dag number 146. None were never used by them.
No, not used by them, but
It was with us. Dag number 146 Well, they have not used it, it is a vacant plot of land.
No, vacant plot of land.
So
Order-
requisition does not mean
So it is your case that position was all,
all along with us.
but they say different thing. No.
They said, that is a different matter, my lord. They are the pattadars. They said they also.
Then if this dispute remains, then I'll relegate everybody to civil court.
In fact,
Then if you dispute about this possession and all this thing,
no,
you fight it out for next
no,
50 years.
it's a legal issue, my lord. It's a legal issue.
No, question is with the 1986 order, requisition order was made. Meaning thereby, you are deprived from enjoying the fruits of the land. Right? That they have kept with them.
Now, my basic.
They have
challenge-
never utilized for.
That's
past time.
right, that's right. The
Right.
basic challenge. So it's
But-
temporary purpose. Requisition is always temporary.
Requisition is always temporary.
Temporary. They cannot.
Right, ownership remains with the person,
Mm.
but the possession is taken. Right? So, de-requisition is temporary. Ultimately, it has either to restitution, shall result in restitution
No, we say.
along with payment of requisition amount, or it can be acquired.
Acquired, my lord, under the provision of.
Either of the two.
Two. They have
Right.
not acquired.
I have understood that, but why you are
No,
going
I'm
in that
only,
direction? That is why I want to know.
I'm only saying because of their taking plea. That is, see, you cannot say that you are dispossessed. We always had the constructive possession. Constructive possession were there
No. But on the other hand,
because we sold
Mr.
it.
Das case is they have received requisition amount.
Yes. His signature is also there, my lord.
See,
I have the original copy.
you have to reconcile
No, but
because
requisition amount and compensation under the LA Act are different. It's only hiring.
oh, they have said they are admitting that state is also admitting that they have requisition. They are not disputing that they are acquired. Right? Now, the us is pointing out to some demand draft and saying that requisition amount up to a particular period was given,
Not to them. They said not to them.
but it was issued,
Issued. Okay.
disbursed. Right? For the same land, DAG number for 146. Meaning thereby, authority has assumed that they are in possession of the land, so they are required to pay requisition amount. They have disbursed. Who had received, who had enjoyed, that is a different matter altogether. And after a particular period, no amount was paid. That
Yes,
is what the
boss.
case is. And they have indicated the demand draft number also, check number also.
Our
This,
case is not that.
this paper.
And against
original
this
copy.
particular land. Ultimately, Priyonath Sharma or Harinath Sharma is the owner.
Hmm.
Yes, yes, yes.
And all of you are under him. All of you. Plus the purchasers,
Purchaser,
whatever, under you. So basically, it is this land under 9 bigha something,
Yes, 9 bigha, my lord.
9 bigha something,
Yes, ma'am.
which you have been deprived of from enjoying since 1986. Basically those. And out of Harinath Sharma's successors, who is enjoying what? We are not. Only- Only your case should be against the state.
State. Simple, my lord. They can,
State.
whether they can after so many years say that the purpose can be changed.
Whatever, either you restitute,
Oh, yes.
restore, or acquire.
My lord, I want to place, my lord, one on one.
We are not
copy line.
today.
Just one single paragraph.
Correction is required or not?
No, my lord, just want to place just one paragraph short. That as an area of 9 bigha 3 katha of land was admittedly requisition, but requisition compensation was paid in respect of 7 bigha.
No, I have found out.
Yes, my
2
lord.
bigha, 2 katha went missing. That
Yes,
is your
sir.
case.
2 bigha 2 katha 6 lessons of land and the interest of delayed payments so and so. But out of that portion has been mentioned in my earlier representation, it was in the year 2008, my lord. Here it is, thereafter, based on the consent of the commissioner, GMC land measuring 7 bigha 14 lesser covered by DAG number so-and-so was de-requisitioned by the additional deputy commissioner, Kamrup height order dated so-and-so, and after obtaining requisite sale permission dated so-and-so, my lord, for 1 bigha 4 lesser sold land measuring 2 bigha 3 katha 14 lessons to some 26 persons. That's why, my lord, 7 bigha 14 lesser was calculated. So I am not concerned. That's why, my lord, that as the, my lord, one portion has been already sold it out by the respondent, my lord. So I am concerned about, my lord, 7 bigha 14 lesser only. Out of 9 bigha, my lord, 3 kathas.
They are concerned.
But I am not concerned.
I don't know. Ultimately, it is 9 bigha 3 katha.
Ultimately, it is, my lord,
9
there, but it, that has
Some
been,
in substance.
yes, here, my lord, in this application, it is mentioned, my lord, 1
No,
bigha.
you have serious story, 2 katha, 2 bigha, went in missing somewhere, something,
But
something.
that has been sold it out to the.
Whatever, they have sold it
They are
out,
not
but
agreed.
all these persons are before this court.
Yes, my lord. As a
Mister, I
respect-
am not going to dispute.
Yes, yes, yes.
Decide your nephew, uncle's dispute,
Yes, my lord.
Right.
That is correct, my lord.
right?
That is why, my lord,
Don't make
They have also given,
nephew, uncle, I am not going to decide.
my lord, in
I
review,
am deciding the case of Horinath or Priyanath Sharma
Yes, sir.
versus State of Assam.
in,
Am I clear?
yes, my lord. 9 bigha.
I doubt
No, 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 my lord.
that.
My case is that only.
And that, they have
Priyanath
also received,
Horinath Sharma versus State.
yes, my lord. They have also
Don't-
received that amount,
I have recorded all the facts.
original.
Go through it. I have recorded whatever
Yes, they are also
is
rightly.
stated in the every read petition. Now, thereafter, discussion will be left to me what to decide. So basically, it is Horinath or Priyanath Sharma versus
State version.
State of us.
his land is enjoyed by state. That is the case.
As earlier, they have also received, we are not, we
Huh?
have, as earlier, they have received by putting their signature in the record.
We are not
Yes.
going to that. I'll make a comment that the dispute about this requisition amount already
Yes.
disbursed. And that is up to the family members of Horinath Sharma to
All,
resolve, right?
yes, ma'am.
My lord, even after receiving requisition compensation, the authority can de-requisition. Requisition compensation
Yes, yes.
doesn't end.
No, basically, it is a kind of tenancy.
Yes, tenancy, lordship is right. That is what the Supreme, this honorable court has said.
এই বাকিখিনি আমি ইয়াৰ পৰা লিখি দিম। বাকিখিনি ইয়াৰ পৰা লিখি দিম। Mr. Das, I'll record your submission also, whatever you have written in the submission.
Yes, ma'am.
Okay, we'll proceed accordingly thereafter.
I have
And,
not mentioned that.
You
portion.
cite the decisions, what are the laws,
Lordship.
difference between requisition and acquisition. And one more that at the end of the day, when it is found that the state or the land is under
James.
occupation of the state, then what will be the option? What are the directions that can be given?
That's.
There are decisions, there are decisions. of
James,
Supreme-
under the JMC.
There are decisions of Supreme Court, how to go about it.
Lordship, right. That aspect.
What kind of mandamus can be given?
Yes, yes.
Yes, ma'am.
That is what,
GMC council, man, inform me, malad, there is a verification.
no, Mr. Das, we are not this verification. Lesa and Katha.
Yes, my lord. Regarding.
Don't make submission on Lesa and Kathas. Address on the point of
Yes.
law.
Yes.
Am I clear?
Yes, lordship is correct.
Address on the point of law.
As a,
This 1 lakh has been enjoyed by the other family, other members of the family. Don't make those submission in.
yes, it will be better.
Don't make
for all of-
those kind of submissions. I have dispute with my mamas and uncles. Don't make some. 7-9.